Yes, Mr.
Main
Jamil.
instructions. Item 26 in the main list. That is the last item for hearing. The matter was listed on 20th May for admission. And then along with the main review, there was also filed for suspension of pending order. But then it was agreed by all the parties that instead of considering the incident, why not fix the matter for hearing? So it is listed in the hearing list. However, the registry has arranged the hearing list in such a manner that it was arranged in sequence in terms of the year of filing. But then on 20th May, the order was passed that if the matter could not be heard on that day, then the incident may be considered. That was the order passed. So, of course, subject to the competence of the Honorable Court. If this item is upgraded, since it was for final disposal, it is already admitted on that day. So, if it is committed to the Honorable Court, this matter may be upgraded.
Mr. Jamil, let us look into it. We see a big line of councils out there. Let's see how it goes, and thereafter we'll consider your request.
Very well put. Otherwise, Lordship, I have an alternative prayer. Will it be possible to consider tomorrow also?
Let's see how it works.
Right.
Item 22. A similar one is requested, but my item is when it's very short. It's only on the point of condonation of delay in filing the writ appeal. But the difficult date of the last day of hearing.
The delay has not yet been condoned.
No, because
No. We'll take it up immediately after the admissions.
so.
What is any item 17? It has my lord has become infectious. Well, application was allowed this year also. When we went to execute the bail order, by awarding permissions by the general authorities, this sentence has already been covered, then he has already been this form.
The bail has been infructuous.
Yes. So when we went to execute his service, his sentence was already.
So you therefore submit that this appeals you don't want to proceed.
Yes, my lord.
Mr. Santiago, the learned counsel appearing on behalf of the appellant, submits that the instant appeal had become infructuous inasmuch as the appellant have already been released on bail.
My lord, in the order,
Huh?
in the order passed to them, after my name, if you can kindly be written by the legal aid counsel.
Okay. Put it legal aid counsel. Mr. So-and-so appears on behalf of the state of Nagaland. Mr. Imtim Song, the learned additional advocate general, appears on behalf of the state of Nagaland. Considering the above, the instant appeal stands closed on withdrawal
My lord.
as it had become infructuous.
My lords, I'm for you informant. I'm also legal aid counsel.
Mr. So-and-so appears on behalf of the informant.
Lord, item 15, I am for the respondent numbers 2 and 3. Here, as per the order dated 11/3/2026, this matter is not to be listed before one of my lords.
Okay, list this matter before any other bench other than one of us. Put madam's name.
What keeps I back in 1998? I mean, making mention on behalf of my seniors in Mawapad. He's out of station. So the matter came up after 2 weeks.
Is inside this person?
Yes.
It has been submitted by Mr. So-and-so, the learned counsel appearing on behalf of the appellant, that Mr. Lima Wapang, the learned counsel, is not available today and as such seeks for an accommodation. List this matter again on 17th of June.
That is,
Yes,
I wrote a big commission item number 8.
8.
Yes.
Yes.
My lord, I have received a scanned copy of the labor books. But the original one is not ours.
It's okay, no problem.
So the latest may come up after we go. Next week.
Let us see a photocopy of the scanned copy.
Yes, I have one.
Fantastic. We'll take it up when the matter is there.
I think commission item number 10 and 11 and 12.
Same
I
problem.
yet to reflect instruction.
We will look into it. All these matters. Because these are matters of habeas corpus.
Yes, my lord.
These matters, notices were issued far long time back.
That's not
You are here, you are only to say. huh?
You will pay payment. You will pay.
18 months.
But I'm
But,
appealing for.
Yes, Mr. Counsel.
Yes, my lord, matter may be hard today, my lord. Reports are available.
Okay, let us see when the matter reaches.
My lord.
Please, Lord Chiefs. Lord Chiefs, I beg to mention item number 16 and 18.
16 is already done. No.
So the bill is already done.
Has been adjourned. 16,
and 18.
16 and 18.
18. Okay,
Yes, sir.
okay. Have we not adjourned 16 now? Okay. Separate orders, huh? Mr. So-and-so, the learned counsel who appears on behalf of the appellants in 16 appellants and in 18 appellants, both appellants, submits that Mr. Ajo, the learned senior counsel who is appearing on behalf of the appellants on account of emergency had to leave to his native village. He therefore submits that the matter may be adjourned to be listed next week, 9th of June,
18 next weekend for 16, my lord, I'm doing it.
17th, 17th. 17. Are you saying that because of Mr. Ajo, we should have another division bench? No. The matter again on 17th of June, 2026.
My lord, in item 18, my senior agent name may be reflected as legal aid counsel.
18 is,
Item number 18.
Mr. Ajo's name is there.
Yes, in 18.
18 also it is there.
As legal aid counsel.
Legal aid.
Amendments.
Legal aid counsel, why should it be reflected? Then you will say,
Number 16. But the person, the video appeared in the post list will be deleted and should be replaced by me.
it should be reflected as PP. In addition to that, it is also seen from the, I'll put it in item 18, huh? It is also seen, in addition to above, it is also seen that in item number, in the instant appeal, the name of the PP Nagaland have not been reflected. The registry shall do the needful.
Much more.
I'd like to mention item number 5. Last occasion, file no report was closed for. However, confirmed from our bench official that it's still awaited. File no report, still awaited, so
It's a habeas corpus of 2025.
yes,
We are in the year 2026.
please on there. It's on there.
He's on bail
Yes,
and he's not inside.
no.
So then matter has become heavy, infructuous then. Habeas corpus for what?
For the issue of age, now the petition is here claiming that she's a minor. Whereas the report, conflicting the report, the report is a measure, so that is the issue.
But would a writ of habeas corpus be there in that regard? Habeas corpus is, if I understand correctly, it is for production of a person before the court. So if he is outside, as regards the age determination, which is to be done as per the juvenile that Justice Act.
If it's a risky person, how come he's inside? If it's outside, that's.
No production. Let us look into it at item number 5 when we take it up in the hearing.
Affecting mention item number 20 from the hearing.
20?
20.
20.
My seniors have some personal difficulties today, so if this matter can come to this.
At the request of the learned counsel appearing on behalf of the appellant, the matter stands adjourned to be listed on 24th of June.
For admission, item number 1.
Here is your.
The last order.
Last order, the two forms, we can just launch it.
When 3, 4, 5 loud. Yes, for this. 3, 4, 5. Yes, for this.
Yes, we have asked the Chief Engineer PWD National Highway to be present. Yes, Mr. Chief Engineer. Why the physical progress is so in respect to this stretch from the chain is 172.900 to 185.540? Not adequate.
Yes,
Why?
respected sir. Actually, there is a change of scope in the estimate. And also the progress report that we have submitted is as per the DPR. But in the ground reality, since there is additional works that has to be done, we have taken it to the ministry. And the ministry has been kind enough to come on day 24th, 25th and 26th of this month. They've inspected the site and then lots of changes have been done and they have told us to write a letter to the geology mining, which we have already done 2 days back, sir.
So therefore, you on account of certain subsequent events,
Yes,
taking into account that the scope of the work has changed,
yes.
there has been no work or no physical progress.
Actually, there is work is there on the ground, sir, but as per the DPR, we have to show as almost nil or 0, sir, because the DPR and the actual work do not tally, sir.
Okay.
Sir, also the bitumen was an issue
Hmm.
because the bitumen cost was high. So the ministry has been kind enough to approve the change in the rate of system.
Change of the
Yes,
rates.
sir. That was where about the approval. Now,
Mr. Chief Engineer, you are looking into the entire stretch, I suppose, from Kohima, from Dimapur onwards till here?
sir.
Okay, that is done by the NHIDCL. Because Mr. Takama said, while coming, I saw the roads have become, last time when I was here in the month of March, it was much better. Now it has, there are a lot of areas where it has broken off in that stretch, which is said to be more particularly the package,
I'm raising that issue today also.
package 1 and package 2. It is in a way bad shape. Means
Yes.
if you don't do anything out there, it would be very difficult.
In fact, last week also I had traveled,
Hmm.
so I was thinking to raise those issues.
Yeah.
Now, with regard to the present personal appearance, Lordship, with regard to this issue, since the chief engineer has personally appeared and raised the subsequent developments which we were not aware. My respectful submission is that they did find a comprehensive affidavit. What is the change of scope and what has been done so far, so that all this honorable board would be abreast of all the issues. That is one.
In fact, we think that when the chief engineer has mentioned it as 0,
Yes,
he should have explained the reason at that point of time itself, why it had become 0, because it cannot be shown anything in view of the change in the scope. The other works which have been done out there do not come within the scope of the DPR.
it appears Lordship, the spokesman officials were not sensitive to that issue. So I accept that point of view. But another important issue, Lordship, with regard to the black topic. Now, on the last occasion, because of escalation of the post, you were expressing difficulties. But now, since the good news is that the price has been approved, I would like the chief engineer to file an affidavit by when he can start and complete the black pocket with this. Because since it is a sinking area and in the.
And more particularly, the monsoons are just
Yes.
in the corner.
To change of scope, we accept that. Another issue, Lordship, the contractor was included as respondent number 20. The contractor who is executing the work, the Send and Go company. Respondent number 21 was included long back, and if I remember correctly, it was directed the executive engineer to inform the contractor. Until date, after implementing the contractor is able to make disappearance in the court. In fact, he's the one who is executing it on the ground. He should be answering to all these issues. Because change of scope and other issues. If the
Mr. Takawasa, you see, the work NHA DCL is required to carry out. We are concerned with that area. You must be referring to.
Because till the extreme, till the junction, it is NHI DCL. Thereafter, it is at the same.
You are referring to the contractor of the within the states.
Exactly. The one who is executing the work, for which purpose the chief engineer is compelled to appear today. In fact, the respondent number 21 should have appeared in highlight this another part about the exchange of scope and all the development here. This situation would have arisen. So my respectful submission is that if the chief engineer may kindly be directed to inform the contractor to take appearance, in spite of implement, the contractor is not appearing so far.
Mr. Takama said the thing is like this. It is the state's duty to do the work.
Exactly.
Similarly, NHITCL is also the state.
Okay, yes.
It is their duty to do the work. Now, if they fail to do the work, actually, for the purpose of the PIL, we should hold the state authorities liable for
I
that.
fully agree.
And we should pass direction against them. Now, the contractor, they have a right or a power as per the contract to do the needful or take up action against the contractor for not doing it. So therefore, if the contractor does not want to appear, in spite of notice having been served, if any order is passed, it will be passed at his risk. I think better off. But if we ask the chief engineer to inform him to appear, I think the majesty of this court will
I
be
agree.
reduced.
Well, if that is because earlier occasions, the order was following that the executive engineer concerned was directed to inform. But thereafter also that very only I am concerned for that. I follow your lordship.
We didn't do this system.
But informally, not.
So it's.
Well, we have informed. We have informed him, and he knows about the matter. If he doesn't want to appear, we post the elections.
But since the issue is raised, I hope that good sense prevail and democratic place.
Yes,
Since I'm raising this issue of his non-appearance, and definitely he'll be aware of what is happening. So I hope good sense prevail and democratic affairs the next stage.
the contractor wants to be a fence sitter.
Yes, sir.
So
So I think
it
it is
will
my-
be at his own peril.
Like,
If
so
he
that-
Mr. Takama says if he doesn't appear, it will be at his own peril.
Yes,
Tomorrow, if we pass an order against him, he cannot say later on that I was not heard. There are orders by which we will take note of that we hope that the chief engineer must have informed the contractor about what the court had asked him to appear. And if he has,
The meeting was.
so therefore, if he does not appear, that is at his peril. We put it out there in the.
I'm happy that the notice is kind enough to keep the comments. So I'll just try to convey the message directly.
So that is one, two. And what about the present package 1 and 2? I think 3 is better now. 1 and 2, why there is so much of potholes and breaking off of these?
Yes,
roads?
but besides that, torture for diversion of the lightening of the river. In package 1, the landslide area, torture must have seen it was decided, the contract was awarded to widen the other side of the river bank. But except for this, but the progress is very slow. In fact, most the torture must say the thing. Unfinished work, just removing the earth and nothing has been done. And that is one, but now this season also, if that. widening is not properly done,
I think now, from now onwards,
it is sinking.
they would obviously come up and say that monsoons have come.
In fact, half of the portion, road is already up. That particular portion, not because the wall is gone and the widening on the other bank, up the river bank. Progress is.
In fact, Mr. Takama, sir, on one hand, NHIDCL or NHI boasts that we are making roads into particular levels of the country. And it's a very sorry state of affairs that the 54, it's a 54 kilometer stretch have not been able to be completed for the last so many years.
In fact, Lordship, this Sumudu PIL, I'm appearing for your Lordship since 2019. Last 7 years. In last 7 years, and the Sumudu PIL was constituted after the expiry of the period of 3 years. So since the last 7 years, we are monitoring this.
Right, it means in spite of orders being passed by this court, and means it is not that it is only in this area this has happened. Yes, even in areas, if you see in the NC Hills also in Assam, they have been able to make the construction
Yes.
where you have the same type of soil. You don't have a different soil from what you are having out here in Nagaland. The same soil is there in NC Hills. I would have understood, okay, they may say that in areas like Simla and all these areas or Himachal Pradesh, the soil is different. But NC Hills soil is same like here. You have the same thing out there in Arunachal Pradesh. Now, Mr. Chief Engineer, you must have noticed they have made a fantastic highway from this particular place near Gauhati, the Holongi bypass. And now the entire road which has been constructed from Naharlagun to Itanagar to Naharlagun, only a small piece portion is left. But that has been constructed, the same type of soil. But I don't understand why this particular portion have not been able to be completed by the NHIDCL. I'm not saying you because you are not responsible. Who is the NHIDCL council, Mr. Muajamir? Why? Why don't you put it out there in your advertisements? where you keep on boasting that NHIDCL has been doing a lot of things, but they have not been able to complete the simple stretch of 54 kilometers.
In fact, Lordship, the paragraph 3 and 4 of the last one. Now, I've been raising the issue of difficult this being faced every year. Now, finally, we have decided to come to go for a permanent solution after last 7 years. Now, that Lordship, if Lordship can see paragraph 3 and 4.
But what about this respondent 6 and 7, the affidavit? Completion certificate is filed. Okay.
Respondent 6 and 7 are taking little time, Lordship. If Lordship can see the paragraph 3 and 4. Paragraph starts from paragraph 3. If you corresponding to paragraph 3 and 4, NHIDCL has filed an affidavit, Lordship. If Lordship can kindly go to the NHIDCL affidavit, paragraph 3 and 4, which was affidavit filed on first.
Yes. So tender will be floated in the first week of September.
No, besides this, Lordship is very confident. All of the maintenance in the package 1 increase extremely poor. So I directly be given to the NHIDCL to ensure that they properly maintain the roads.
As far as package 1 is concerned, Lordship, we have engaged the contractor for short-term maintenance, Lordship, for package 1. And for package 2, Lordship, it is under defect liability period, Lordship. It's for a period of 5 years. So the contractor.
Are you taking up steps against the contractor
Is it?
when it is under the defect liability period?
And also, Lordship, the contractors who is cutting the opening of the road, the riverbank on the other side. I would like the NHIDCL to highlight what is the position, because progress is almost new.
We do one thing, let us fix this matter after 2 months, not now. In the meantime, let us see the progress of this state package in view of what statements have been made today or the submission made by the chief engineer. We also take note of, we also find it as regards the slope protection and all, they are going for a fresh tender in the month of September. That is okay. Let them give a update as to what has happened, because there are a lot of other formalities to be done prior to that. We take note of that they have engaged some contractor for the package 1 for the purpose of maintenance. And NHIDCL shall ensure that the contractor does the needful. And further, we also take note of that he submits that it is under the defect liability period. And as such, if there is anything wrong, you take note of it and do the needful. I think that is a better.
Lordship, with regard to the state portion, my respectful submission that the affidavit to be filed by the JV here. If
No, no,
you give
that is
a
what-
timeline for that copying of the drawing.
No, we are not, so we say, you hear what order I'm
What?
asking?
What?
Lordship, I
Yes,
That means we present the we will get out, we draw. And then there's a component which will be shade or something that will be because of the fire. So if that will be recorded, and my name is. That's all.
you are appearing for respond number 9.
19.
19, for which package?
For slow rotation work and for promotional.
But we are made to understand that as regards to this.
Film for the books now, but that I'll be nobody presenting at one game. So if that maybe. The company is available.
I will be presenting the company correspondent number 19, which is MIPL, Mandatory Infrastructure Private Limited. Mr. Jamil was representing us earlier. There is a change of counsel here. I have another counsel. However, I also have the Wakalatama. I am the
So,
counsel.
Mr. Jami, you won't be appearing any further for respond number 19. You will be appearing.
Sir, just wants his name to be.
Okay. Thank you.
My fresh Wakalatama along with. my
It's okay, no
counsel is
problem.
Based on record. Lordship, I've also filed an affidavit, which is, I thought is already on record on behalf of respondent number 19.
Okay, what does it say?
My scope of work as MIT respondent number 19 was only pertaining to rockfall protection and slope protection.
Hmm.
As per the affidavit is 90, almost 99.
Rockfall protection and slope
Protection.
protection.
Protection. Slope protection. Stopping the derbies, to ensure that the rocks and derbies don't fall from the slope. So that was the initial work.
Okay.
And after that, the main road, which was to be, that's not my work of, so almost 99.81% of the entire work of slope protection work has been completed by me, which was my scope of work.
So you completed 99.18.
81, yeah.
81% you have completed
In
as
terms of-
regards both rockfall and
Yes, Your Lordship,
and slope.
and that's stated in para 2 of my affidavit.
okay.
My present site engineer is also present in person. In case Your Lordship has any query technically, he can
No.
answer. And
You see, Mr. Counsel, it may not be, we are not expertise on this aspect. Let the NHIDCL executive, what do you call the executive authority, no? Huh? Operating engineer, authority engineer. The authority,
They are verified, report on the next day.
the authority engineer will look into that.
definitely, the copy has been supplied.
But we are not here to give a certificate
Yes.
for whether you have completed or not. That's your stand. We take note of it.
My prayer is something else. By pointing out this, I was only stating that I filed an affidavit.
That's
Copies,
okay, no
necessary
problem.
Copies have been supplied.
No, it's okay.
Once-
We will mention that aspect.
Yes, Your Lordship. And my prayer actually was something else. That once this is verified, I understand what is following from down to the board. They have to verify it. Once it is verified, my only prayer that I will remain to be a respondent in the ongoing PIL. My date-to-date representation of my engineer maybe
Is there a direction for your engineer to appear?
on certain dates they were. And
When there is a direction, then you appear.
that
Otherwise, you
exactly
don't.
is my request that if I only may be allowed.
You can, Mr. Counsel, you can very well appear through the video conferencing mode. You need not come over to Kohima, because here we have fantastic video conferencing modes. and the engineer in charge, and more particularly, you see, Chief Justice of India have asked all the high courts out here to also have the hybrid system, and we are also following that mandate. So therefore, you need not appear out there. Okay. Pursuant to the order passed by this court on 22/4/2026. The present proceedings have been listed before us. First, there was a direction upon the Chief Engineer PWD National Highway to appear in person and explain as to how the physical progress had been nil. Bracket 0% for the last 3 weeks, for 0%, as well as to also explain the poor quality of bituminous carpeting on the stretch of road from Jotsoma bypass to Leri Welcome Gate, and to also provide an action plan on how the same would be maintained. In pursuance to the aforesaid directions, Mr. So-and-so, the Chief Engineer, PWD National Highway, is present before us. The Chief Engineer, PWD National Highway, submitted that there has been a change in the scope of the work. And in that regard, the Ministry of Road Transport and Highway, officials of the Ministry of Road Transport and Highway, have also visited the site on 24th, 25th of May 2026 and have directed the State National Highway Authority, State PWD, to submit certain proposals. The Chief Engineer further submitted that in consonance to that, steps have been taken for submission of proposal. In addition to that, the Chief Engineer also explained as to why, in the affidavit so filed, it was reflected that the physical progress of the work was nil. The Chief Engineer submitted that on account of the change in the scope, other works were being carried out which were not connected with the DPR, and therefore the progress could not be shown. In addition to that, the Chief Engineer also mentioned that as regards the bituminous carpeting, on account of the price rise and the appropriate sanction not being granted by the Ministry of Road Transport and Highways, the said stretch could not be done. However, in the meantime, the Ministry of Road Transport and Highway had granted the sanction, and steps in that regard now shall be taken. First, Mr. Imsong, this is what it is. Mr. PWD, Chief Engineer PWD, this is what has happened. We think we are of the opinion that these aspects, along with an up-to-date progress, be provided before us by way of an affidavit to be filed by the Chief Engineer PWD National Highway. on or before the next date. Next. We also have taken note of the directions which were passed by, the directions passed in the order dated 22/4/2026, more particularly at paragraph number 3 and 4. And there was a direction upon the respondent number 6 and 7 to file an affidavit giving an up-to-date status. In pursuance to that, an affidavit has been filed by the respondent number 6 and 7 on 2nd of June 2026, wherein it is mentioned that the DPR is presently at the stage of finalization in respect of slope protection measures along the entire stretch falling under package 1, package Roman 2, package Roman 1, package Roman 2, and package Roman 3. It is also mentioned that the DPR consultant would submit the final DPR on 30/6/2026. Additionally, it is also stated that from 12/5/2026 to 14/5/2026, the peer review expert had visited the site for the purpose of carrying out scrutiny and assessment of the shoulders proposed by the DPR consultant concerning the slope protection, valley side protection, etc. It is also mentioned that upon the finalization of the DPR, the same has to be approved by the NHID-DCL. And thereupon, by mid-September 2026, and thereupon, on first week of September 2026, after floating the tender, the contractor would be finalized by first week of December. This court we have also taken note of that in the said affidavit, we've taken note of paragraph number 3 of the said affidavit, wherein it is also mentioned that there are other formalities to be completed in the meantime. In addition to that, it is mentioned that the NHIDCL have also directed the concerned contractor in respect to the package number 3 to augment its resources so that the work is completed by the end of July 2026. Further to that, it is also mentioned that insofar as the slope protection works and it mentioned that as per the scope of work, the slope protection works have been completed at the site. The SPM had visited the site from 5/6/2026 to 9/5/2026 to review and verify the completed works and have concurred with the works executed. Documentation for issuance of the completion certificate is under progress. Insofar as the RCC box tunnel projects are concerned, they are in progress and likely to be completed by June 2027. In this regard, this court we also find it relevant to take note of the submissions were made on behalf of the learned counsel so-and-so who appears who have been newly engaged and appears on behalf of the respondent number 19. The learned counsel has submitted that an affidavit has been filed by the respondent number 19, wherein it is mentioned that the scope of the work of the respondent number 19 was limited to rockfall and slope protection. In that regard, it is also mentioned that 99.81% of the work have been duly completed. Full stop. We also take note of the submission of Mr. T.B. Jamil, who was earlier engaged to appear on behalf of the respondent number 19. He submits that he is no longer engaged for the respondent number 19 and his name may be struck off in the cause list for the respondent number 19. Along with his associates. First. Mr. Takam next. Mr. Takam, the learned senior counsel, who is also the amicus appointed by this court, have pointed out before this court that while the authorities in the NHIDCL have stated that the work in respect to the package 1 and package 2 is complete, but there is no adequate maintenance. This court on such submissions inquired with Mr. Muajami, the learned counsel appearing on behalf of the NHIDCL. As regards the question of maintenance, Mr. Muajami had submitted that in respect to the package number 1, a contractor has been engaged for the purpose of maintenance. In respect to the package number 2, it is still under the defect liability period of the contractor. First, we are of the opinion that if the maintenance is not being carried out, it is the duty of the NHIDCL to take steps against the erring contractor. We hope and expect the NHIDCL shall do the needful so that in respect to the package number 1 and 2, which have been completed, said to have been completed, the same can be maintained. First. List this matter again on.
Widening of the riverbed. Cutting of the widening of the riverbed. If
I mean, they are allowed to ask few submission.
Yes.
Till the acquisition of the land, that is about counter package 1. The energies they feel that their widening is required. So they have the decision for the acquisition of particular portion of the hill. So other way, then till the acquisition is completed, we were hunted like a terrorism before. And after acquisition, after handing over the particular hill of the energy reserve, we have to release the video of the hill and they are not doing anything now. So there should be a direction to the energy reserve to continue the work to cut the hill. Because it's already
Package number 1.
yes, package number 1. So it is not like a mobilization of the video of the hill down in the package 1. So there is no direction of the new cost.
We also take note of a submission, the submission of Mr. Imti Imsong, the learned additional advocate general. Insofar as the package number 1 is concerned, he submits that the land pertaining to a hillock have already been handed over to the NHIDCL. When? Last year. But till date, there is no progress of work for cutting of the hillock for the purpose of widening
Except cutting of the
widening of the road,
riverbed.
widening of the riverbed.
Riverbed.
No. It will be first cutting of the hillock for the purpose of widening of the road in order to get for I've not taken any steps for the purpose of widening of the riverbed, for the purpose of cutting of the hillock, for widening of the riverbank. First, we are of the opinion that an affidavit in that regard be filed by the NHIDCL as to why no steps in that regard have been taken by the NHIDCL, inasmuch as without the widening of the riverbed, the package number 1 cannot be said to have been completed. First, we accordingly fixed this matter for further consideration on 5th of August 2026. In the meantime, the Chief Engineer PWD, PWD, State Highway, National Highway, shall file an affidavit as regards the up-to-date progress in respect to the portion of the road from Lerigate to Josoma bypass. First, the said affidavit has to be filed on or before 3rd of August 2026. Next, we further direct the NHIDCL to file an affidavit as regards the progress pertaining to the package number 3, as well as to what is the progress relating to cutting of the hillock, so that the riverbed could be enlarged for the road in connection with package number 1. First, anything else? Full stop. In addition to that, the respondent number, the NHIDCL shall also give an update as to what steps have been taken by the concerned contractors in respect to the package number 1 and 2 for the purpose of maintenance of the package of the said roads concerning those packages in the meantime, till the next date. First, in addition, I think that
Since the leader is going to file up, I have no objection if his future president's appearance is disturbed.
no, that is, I'm passing it. First, we have also taken note of the submission of Mr. So-and-so, the learned counsel, who has been newly engaged by the respondent number 19, wherein he submits that taking into account that the respondent number 19 have already completed the work to the extent of 99.81%, there would be no necessity for the site engineer to appear before this court on each and every date. First, we have the opinion that till appropriate directions are not passed, we observe that till appropriate directions are not passed, there would be no necessity for the site engineer of the respondent number 19 to appear before this court. In addition to that, the learned counsel appearing on behalf of the respondent number 19 can avail the hybrid facilities provided by this court if the respondent number 19 wants to put on an appearance on the next date onwards. We also dispense with the further appearance of the Chief Engineer PWD National Highway until further orders. First, next, we also take note of we also take note of that the respondent number 21 have not chosen to appear. 21, na?
Yes.
Chosen to appear. In spite of notice having been served and informed, and also having been informed by the chief engineer, PWD, National Highway. We observe that if the respondent number 21 fails to appear, comma, any order, if the respondent chooses not to appear, comma, they may do so at its own peril.
If the operating engineer in fact is directed to verify and report, then they say about the progress.
Regarding?
Responsibility, we regard the progress of the work in package 19. Respondent 19, not you.
Why should no, we would not, because why should we verify and give him a certificate? No.
Go by the authority engineer.
They have already mentioned, as regard that in paragraph number 4 of the affidavit which have been mentioned, they say work is completed. The counsel for the petitioner, respondent number 19 says it is 99.81. But the NHIDCL says in the affidavit that it is 100%. Okay. I've recorded that.
Coordination, item number 2.
These lordships. The lordships, we have received the affidavit filed by the legal respondent number 1 this morning. I'm for the intervener respondent number 8, the lordships. But here, according to the affidavit filed by the union, the dispute still persists. According to us, the petitioner as well as the intervener respondent number 8, dispute is already resolved. So based on this affidavit, we may need some time to seek advice, some advice from our clients, your lordships.
What happened pursuant to our order of 25/3/2026?
Lordships, according to the union affidavit, it's paragraph number 7, the process of the NIT is completed, but because of the persisting dispute amongst the parties, they could not take the further step. That is the excuse given here. According to us, the dispute is already resolved. But the last annexed share, letter dated 1st May 2026, annexed to the affidavit filed this morning. Apparently, the PWD department, government of Nagaland, has also written a letter to the union stating that the dispute is persisting. According to our instruction, dispute is already resolved. We need to take some time to seek the advice.
So therefore, we directed the central government to file an affidavit in our order. Taking into account, here it was a case where a particular road, 329A.
Yes, Lord.
329A, there was no construction being carried out in spite of there being a direction in the PR already. And they diverted or bifurcated this thing to something else.
Yes, 129A. It was done.
Now, therefore, when there was a direction, there was a necessity for the union to say. Now, union comes up and says that, look here, there is a dispute amongst the villagers. And because of that, we are not in a position to progress. On the other hand, you say there's no dispute.
According to our instruction, the dispute is already
Who
resolved.
are you?
I'm the intervener respondent number 8, Lordship.
Who is for the petitioner? Yes, madam, you are the main person. Where is Mr. A.G. Momi?
It's a personal relating to them.
Ah.
But not,
PIL is being taken up with the council. First of all, you shouldn't be filing PILs. You see, public interest litigation, the responsibility is not like another repetition. It is only for the particular person. Here, you are representing the entire mass. So you cannot come up and say that he is not there. You have to be very careful.
not as per the, not,
This is the Pimla to Minamsi junction.
yes,
isn't it?
yes. Not the, the stand which the union has taken here, we are also saying that the issues have already been resolved, my lord, as per the instructions we have received from our client. So if I may be also granted some time to counter this affidavit which they have filed, my lord.
No, my question is, union says that there are certain disputes which are going on as regards those persons who are the landholders of the road in question.
Yes,
That's the union saying.
yes,
You say that there is no dispute.
no,
You also say that there is no dispute.
yes.
Now, my question is, who are you, both of you, to say that?
Your worship.
Can you say that, taking into account, it is tomorrow both of you say, and we pass an order, okay, there's no dispute. But wouldn't it affect the rights of those persons concerned who would be otherwise affected because of your submission?
Worship, the entire stretch is our lands.
Your land?
The other villages are represented by the petitioners and the intervener. The last village, my name village. Respondent will.
Understood. So you are appealing for whom?
I'm for the nine village. The intervener.
Understood, but village is okay. I've seen many cases out here where the village chairman or whoever it may be, they come up and say that we have no objection, take over the land. Then comes those persons concerned, the landowner. Who is he to say all these things? Isn't it, Mr.
The
Sankar?
lordships will
Huh?
file an affidavit and place all the material reports.
This is a very difficult thing. You do one thing. I think as the central government says that, we direct the DC concerned to issue a obligate notice to all concerned as to whether they have any objection as regards this. And have it after 2 months. In the meantime, you can submit a report on that. If you have anybody has an objection here, you in the meantime, you are respondent, you are the last village, you ask all these people that they don't have any objection and give it before the DC, and the DC will submit a report before us. Then obviously the objection which the CGC has made is taken care of. Madam is out here saying that I take care of 4 villages, no? 4. You are the 5th.
Yes, I'm for the last village, Your Worship. There will be
Some more in between.
At your instance, how can we say that there is no objection? Because each person will later on come up and say, one person will later on come and say, I never knew anything. Isn't it, Mr. Engavat?
Yes.
This is a big problem which I see everywhere. Yesterday, Mr. Sankam was making an argument that we, in good conscience, we thought that the roads are necessary. We had said that, okay, we'll provide the roads free of cost. And of which those persons have duly agreed, the village chiefs. And later on, all these persons comes out that my land has been taken, Article 300A. How do you tackle that?
Worship, the boundary has not been drawn as yet between Pereira and Chunkedima district. So to get to commissioners,
They may issue a notice. They may issue a notice giving wide publication as to whether there is any dispute. And if there is a dispute in using of that right of way, in that right of way there is dispute, those persons may very well appear. And then they'll let them submit a report before us, then that will take care of you. Your affidavit in reply would not help us. What do you think?
Yes. Individual landowners and
They will come.
other villages and dams.
By an order dated 25/3/2026, in the present public interest litigation, we granted a final opportunity to the respondent number 1 to place instructions before us as regards the outcome of the notice inviting tender dated 8/12/2024, as well as what further actions have been taken for the purpose of converting the intermediate land to two-lane in NH 329A. An affidavit in that regard has been filed by the Union of India on 2nd of June 2026. In the same affidavit, it is mentioned
Barang lain Mas Prohibition.
Era,
Barang lain.
it is mentioned that those notice inviting tender dated 8/11/2024 was issued for engagement of project management consultancy services for upgradation of the NH 329A to a two-lane with paved shoulder. The said tender process was completed. However, further action towards approval of the sanction and commencement of consultancy services could not be taken up due to unresolved land disputes. The delay, it is further mentioned that the delay in further sanction approval and commencement of work was primarily on account of unresolved land and boundary disputes presently under consideration of the state government. The Commissioner and Secretary to the Government of Nagaland, by letter dated 1/5/2026, had reiterated that the work in question cannot be commenced as the boundary/land dispute is yet to be resolved by the state government, and has stated that the work shall be initiated immediately upon resolution of the dispute by the state government. First, Ms. So-and-so, the Land Council appearing on behalf of the petitioner, and Mr. So-and-so, who appears on behalf of the respondent number 8, respondent number 8, in the capacity as an intervener, submits that there is no dispute. It is the opinion of this court that mere statements on behalf of the petitioner or the respondent number 8 could not suffice in respect to the reasons so assigned by the central government for not progressing with the work of conversion of the intermediate land to a two-lane road, that is National Highway 329A with paved shoulders. This we observe taking into account that there might be various landowners who may be interested in their rights under Article 300A of the Constitution. And if there is such disputes in respect to while ascertaining the right of way, there would be a necessity of taking appropriate steps. Be that as it may, we are of the opinion that as to whether there has been a dispute or not, there is an unresolved dispute or not, can be ascertained by the concerned Deputy Commissioner of the districts of Pek and Chumukidima and Ferren. We accordingly direct the Deputy Commissioners of both Ferren and Chumukidima to issue public notices to issue public notices as well as respective notices to the persons within whose land the right of way in respect to the road in question would fall. And thereupon ascertain as to whether there is any dispute. First, the deputy commissioner of the both the district shall also, while ascertaining the same, take undertakings from each of the landowners within whose land the right of way falls, as to whether they would claim any right over those lands in respect to wherein the right of way of the land of the road falls. We further direct that these public notices so directed herein above be issued by a newspaper publication which is widely circulated in the districts of Peren and Chumukidima. A report in that regard be placed by the district commissioner, the deputy commissioners, Chumukidima as well as Peren before us on or before the next date. List this matter again on 24th of August 2020, 19th of August 2026 for an update.
For admission, item number 3.
Not since by already dated 25/2026, I was directed to take fresh steps upon this number before. Use of this policy.
Huh?
By order dated 13/5/2026, I was directed to take fresh steps upon the this number before. I have taken fresh steps on 18th of this month, my lord. Last month.
Order
Yes, my lord. Order dated 13/5/2026.
226.
13/5.
13.5. Where is that?
13 of
13.5.
Yes, my lord.
The notice of reserve was so issued by the registry on demand. Long time has elapsed since the issuance of the notice. Accordingly, the applicant is directed to take fresh steps on issuance by the alia by steps within 2 working days from today's that the interim order passed earlier shall continue till the next date. Okay, who is respondent number 4?
He is challenging my appointment. I have been appointed on compassionate basis.
Huh?
I have been appointed on compassionate basis after the demise of my husband in harness,
Ah.
under the excise department. Now, he was also, while my compassionate appointment application was pending, the government made a stop gap arrangement and the private respondent number 4 was appointed on a probation of 2 years. Without any open advertisement. Now, later on, the department itself revoked the appointment of the private respondent number 4 on 30th of October 2023. While the probation period was not over. And then by order dated 1/11/2023, I was appointed on compassionate basis, along with other similarly situated persons. Now, agreed by my appointment on compassionate basis, the private respondent number 4 referred a petition of orders on number 4. We ordered the single bench of this honorable board with that enter into the question of how the petitioner theory, who is the private respondent number 4 here, had entered the appointment because he made an application before the excise department saying that he is from a poor family.
Who?
The private respondent number 4. And the department held a screening, considering the screening committee, and then the petitioner along with 1 or 2 other persons were given appointment. Now, if that is a ground from a poor family, being a ground for giving appointment.
So private response, your appointment was set aside.
Yes,
So therefore you file a appeal.
yes, my lord.
Now, where does the private respondent remain? Stay.
The private respondents, now immediately after that, my lord, this honorable court has stayed the single bench's decisions.
Ah,
Now I am still in service. The private respondent is yet to be appointed.
okay.
However, my
Now,
lord, I have taken-
now the question is, you are still in service.
Yes, my lord. Still in service.
Then you have to take steps by dusty upon the private respondent number 4.
My lord, my lord.
The reason why I'm saying is, if tomorrow your appointment has been again or your appeal is dismissed,
My lord.
are you going to return the salary which you are getting during the pendency of the appeal?
No, no, no.
That's a very important
Yes,
thing
my lord.
because it is after all government money.
My lord.
Madam may not like it to take it. That's a different thing. We have to consider that.
Yes, my lord.
So we take directive to take service by dusty upon this private respondent.
My lord.
Okay.
My lord.
We have taken note of the order dated 13/5/2026 passed by us, passed by this court, wherein there was a direction issued upon the appellant herein to take steps upon the respondent number 4 by way of speed post within 2 days. Mr. Sentienga, the learned counsel appearing on behalf of the appellant, submits that due steps were taken.
My lord.
However, we don't find that a service have been effected upon the respondent number 4. We have the opinion that taking into account that there is a stay to the order passed by the learned second judge, there is a requirement for an expeditious disposal of the appeal. Considering the above, we fixed this matter again on 29th of July 2026. In the meantime, the petitioner is directed to take steps by way of dusty routed through the registry of this court and steps by way of dusty upon the respondent number 4, routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. The appellant shall also ensure that the steps service is effected upon the respondent number 4 by way of the stay on or before 24th of June 2026. Interim order posterior shall continue till the next.
Thank you, my lord.
For admission, item number 4.
Yes, what is the order?
Well, this worship. My lord, this, the bill is filed challenging the impugning judgment and order dated 13/8/2023, passed in definition number 153 of 2022. My lord, I'm appealed by para 20, 21, 22, and 23. The lordship mechanics see the judgment. Page number 86.
You agree by which one?
Judgment, para 20.
There are 23.
Yeah, para 20.
How many years, Mr. Jamil, you are working?
23 years, daily 23 years.
23 years. Now, as per 1/4/2025, he's in fixed pay.
No, it's scale of.
You are in scale of pay,
Yes,
but you are not being given the same scale with that of a regularly appointed. What is the scale of pay? You have a scale of pay for
I'm doing in terms of ROP 1983.
And the latest RP that's working the fee is probably 17 hours.
Okay,
My
okay,
lord,
okay.
Your lordship, when I see the adjustment, in the last paragraph, it directly does not respondent will consider the petitioner fees as per 2017 ROP method. In the 2017 ROP, it is applicable only to the regular employee. And my lord, the petitioner is not regular. And the appellant is approved by this direction, my lord. And my lord, this implicit judgment was disposed in the line of the justice, state of Punjab and state justice in Malone. There in the para 42, Your Lordship, I can see the judgment.
But whatever may be, whatever may be,
Yes.
State of Punjab versus Jagjit Singh categorically mentions one thing. That is, a person who has been working out there, you cannot give him a salary below a particular level. He is at least entitled to the minimum of the scale of pay.
Yes, that is the problem. I'm taking that is the.
So you are ready for minimum of the scale of pay.
He is already in German, 1993 scale of.
No. Minimum of the scale of pay which is enjoyed by the the regular employee.
My lord, if the petitioner is.
No. That you cannot give as per 1993. No, Mr. Counsel. It has to be as per your latest ROP.
But my lord, in order to like this principle of equal pay for equal rights.
We cannot do that.
My lord,
We dismiss.
so my lord,
It
your
is-
kindly, allow me to give my submission, my lord, in one problem. In order to apply the equal pay for equal work, the.
We do one thing.
Improvement.
No, we do one thing, Mr. Jamil. We admit this
Lord.
and fix it for hearing next week. For final disposal. I think this is an issue which needs to be finished it off, taking into, with no stay. Stay doesn't arise. What the order has been passed by the learned single judge appears to be right. But I have only one problem with that from the date of filing of the representation. It has to be prospective.
Yes, not only that, my lord. Honors of proof is lies in the amendment. Here the petitioner has.
No, Mr. Form, kindly appreciate one thing. You have an ROP of 2017. You have an ROP of 2007. 2017, I think, is the ROP for, is it the ROP 2007 or 17? 17. ROP 2017 is with effect from 2017 to 2000, yeah, that is the, I think, the 7th or 6th or whatever maybe, 7th. You have another at 2007 also. Every 10 years, there is a change. There is another one which is there in 97.
99.
99.
90.
So then you are giving them as per 93. In fact, he should be given from the date you have given regularly all those people from the date others have got 93 from 2017. Isn't it?
My lord say 1999 ROP is not applicable to this case. Here was only the regular employees.
No.
In that will include.
Anyways, We no stay. We reject it and say that it will be taken up for final disposal. There is an appeal filed against the judgment on order dated 13/10/2023 passed in WPC number 153/2022, whereby the learned single judge by the judgment and order directed the respondent number, the appellants herein, to pay the respondent number, the sole respondent here, na?
Yes, yes.
The respondent herein a scale of pay similar to that of the regularly appointed sweeper at a rate that is as per ROP 2017 with the effect from the date of filing of the representation dated 28/10/2021 within a period of 3 months from the date of the said judgment. We have perused the said judgment, the impugned judgment and order, and we are of the opinion that as certain questions of law have been raised, which would have wide significance, while ramifications, we deem it proper to admit the instant appeal. Accordingly, the writ appeal stands admitted. The respondents herein, the registry is directed to list the appeal for final disposal on 17th, huh? 17th. On 17th of June 2026. 2026. Mr. Muajumi, the learned counsel, appears on behalf of the respondent and had also informed that a copy of the writ appeal have also been served upon him. The registry is further directed to connect the records of the instant appeal connect the records of the writ petition with the instant appeal. Not connect. Take the records of the writ petition along with the instant appeal. This is an application filed for stay of the impugned judgment and order dated 13/10/2025, passed in WPC number so and so. 25, na?
Yes.
Are you sure?
Okay.
Huh?
2023.
23. The delay was condoned.
Yes.
23, huh? Shocking, yeah. So taking into account that the instant writ appeal was filed in the year 2026, and there has been inconsiderate 2026, we are not inclined to stay the judgment, impugned judgment and order dated 13/10/2023, passed in WPC number so and so. Accordingly, the instant application stands rejected.
Much more.
For orders, item number 5.
We take that admission, that one. Na? There's one item 20. 22, item 22. What is this? The delay has not been condoned.
Yes, this is not good. There is a delay of 835 days in presenting the appeal. However, as to why the delay has occurred, to explain that, I have to give a brief background of the case. The matter law pertains to construction of Kohima Kohima Road in NH 29, approximately stretch being around 22 kilometers.
Did you appear before the single judge?
Oh, yes, no, I'll just a few words, some background. Now, because of COVID, because that was the onset of COVID. So because of the COVID, there was difficulties in the work. As a result, so after lots of exchanges between the two, NHI DCL the Lord terminated the contract. Now, Lord, the order of termination of contract was under challenge in the writ petition. The single judge dismissed the writ petition, sorry, the single judge the Lord dismissed the writ petition, upheld the order of termination of contract, and at the same time also held that notwithstanding the fact that there is an arbitration clause, the writ petition is maintainable, placing reliance on the construction case. Now, Lord, the disturbing part was, so far as we are concerned, in the judgment, while upholding the order terminating the contract, the single judge gave certain findings on our non-performance, holding us guilty of default in the contract. Be that as it may, Lord, we approached we sought for we invoked the arbitration clause. Arbitration clause was invoked. The NHIDCL deferred and procrastinated over the matter.
So, Mr. Tiwari, well, without going much, I think what has happened, without looking even to the judgment, the learned single judge has confirmed or said that the termination was good, and on the other hand, directed you to approach the arbitral tribunal.
The actions given, the findings were recorded. That
And now in the arbitral tribunal, you are in
yes,
difficulty.
This is what it is. This is what it is important. This is what is
Mr. Counsel, we condone the delay and make that observation that shall not affect that.
No, my lords, it cannot be done.
Why?
Because, my lords, I have taken a plea of res judicata in the arbitration. And, my lords, when on merits, what happened was in the arbitration petition, I raised an issue with respect to the maintainability, saying that there is an arbitral clause. The disputes which he is seeking to raise in the writ petition are also arbitrable. There is an alternative remedy available. But in response to my such plea and objection, he insists upon the Honorable Writ Court that no availability of a mere alternative remedy does not bar.
Where is the impugned judgment?
Yes. Well, it's in the writ appeal, it is page 667.
Page
667.
160.
Annexure A3.
Third volume.
There are 5. There are 5.
But where is the direction?
There are 5 euros to see. There are 5 at page 671.
That's the argument.
Yeah.
No, I'm not there. But where has he been allowed to go to arbitration?
No, he has not been allowed.
So then,
In the writ petition, he is not allowed.
Then,
It's a wrong statement on part of my.
I'm sorry. I did not say that.
Mr.
Asked
Counsel.
the question, I answered by saying, no such direction was there.
Anyways, you are now asking, then they went to arbitration. So the arbitration has a problem with this, because there is no leave granted to go to arbitration.
Yes, now once you have agitated, the law is there, which I'll show the way. The law is there, once you have agitated an issue in a remedy, touching upon the merits and an order is passed, that operates as res judicata. You chose your remedy despite my objection being there, that arbitration is there, still you chose and insisted upon the writ court that no, you please exercise jurisdiction and look into my termination order. So all right.
No, Mr. Counsel, I understand, but there was no direction for him or granted liberty to approach the arbitral tribunal.
Yes, no, Mr. Counsel, it operates in my favor. It operates in my favor. Absence of any such direction or liberty granted to him law operates in my favor, because it could have been a different case that I agitated an issue. Petitioner agitates an issue, gets a judgment, is still, my lords, gets a liberty to agitate the same issue before the learned arbitrator. That would have been a different case.
Why? There is some appeal also? No.
This appeal is very appeal, which he files.
Or there is a PR. Okay.
Yes.
Where, Mr. Tiwari, where is the Delhi High Court judgment?
Yes.
I think I got it.
Yes, it's part of the economic application.
I got it.
Like this.
I got it.
Uh,
This happened on 22/10.
Second volume. Page.
Now,
442,
now does the
448.
Delhi High Court take into consideration that there was no dispute to be referred?
No, my lords, this issue was not informed by the petitioner to the Delhi High Court.
Now, were you not present?
And my objections, all my objections were kept open. The
Where?
problem is not, the problem is in the petition before the Honorable Delhi High Court. And my lords will see in the order, the petitioner does not inform specifically that already there is an order passed by the Honorable Delhi Court on termination. The onus was upon them primarily to inform the court. They do not inform the court.
They don't be informed the court. Court was aware, but I will just place all the facts. My own basically page 427, from panel 16 onwards. In panel 17, they were given the liberty to raise these issues before the arbitrator.
So did you move a section 16 before the arbitrator?
No, lords. We raised an application for rejection of the entire claim on the basis of res judicata. Why, lords? Because
So you did not say that there is no arbitral dispute.
yeah, well, we have said what we have said before the honorable arbitrator. That this plea or the claim which they are agitating now before, because there is an arbitration clause. So once there is an arbitration clause and there is an allegation of a dispute, the dispute may be anything wrong. The arbitrator and others has been appointed. My submission is, Margaret, there can be two kinds of disputes. One, which are not hit by res judicata, the other which are hit by res judicata. So I moved an application before the arbitrator that it is hit by res judicata. The claims are barred. And on that, the arbitrator has to adjudicate whether they are hit by res judicata or they are not hit by res judicata. That is one. Now, what they do.
Yes.
After I have taken this objection before the honorable arbitrator, then they say that now we are going before the honorable writ appeal court, this honorable court. And now we will setting aside of the next single day law. We were not aware that you will take this plea of res judicata. And since you have taken this plea law, now we are going before the writ appeal. Now, this is not allowed under the regime of the law which governs conservation of data. May I just hand over the list of dates as to what has happened in this case, whether I show your lordships that the appellant over here.
You have to override also. Well, we have our own.
And on the aspect as to
So, Mr. Tiwari, you want to say that you did not know that the judgment passed by the learned single judge would act as a adjudicator?
We did not make any such prayer.
No,
This
you
is
didn't
what
make, no,
my
it's,
esteemed colleague,
no, I'm not on that. I'm looking into your appeal, your list of dates. You say that 15/4/2025, respondent filed a statement of defense. 12/9/2025, respondent filed an application raising a plea of res judicata. Writ appeal filed in so and so for condoning the delay of so and so. So are you now saying before us that you were not aware that the judgment passed by the learned single judge would amount to a res judicata?
such a plea we cannot make ignorance of law is no excuse. The appellant may not accept legal position. I would not make any such submission. I would rather submit the law that immediately after the judgment of the learned single judge, we approach the authorities for arbitration. My lord has seen the sequence of events from 27th of June 2023 onwards. Everything. Initially, the without they procrastinated, etc. You know, one may also, there are situations where it happens, at times not the plea of res judicata is also not these. We took our chance when we realized such a plea has been raised now before the sole arbitrator. Then London arbitrator told us, "Look, this is what it is. My hands are tied. You better go to the writ appeal court." That's all we are here. So we can't say that we were ignorant of law. Apparently, they had their own wisdom. They chose to went to the arbitrator straight away. Initially, authorities they don't allow them. They approached the Delhi High Court. Delhi High Court, all the facts were placed. In spite of that, the Delhi High Court appointed the arbitrator, giving them the liberty to raise all questions.
What is your claim before the arbitrator?
Our claim is because we performed approximately 42% of the work. So the work we have performed, we want a payment for that. And
so therefore, how would there be a res judicata? My question is, The termination was held to be legal by this court, by the learned single judge. If the termination has to be held illegal, and there was no issue before the single judge, if I'm not wrong, for payment,
Learned single judge,
because there is no observation made by the single judge that he's not entitled to them.
there is no such observation.
So therefore, your case is before the learned arbitrator. Yes, as regards termination, you may not be able to say anything because this court has already upheld it. But as regards the other claims, whether you are entitled on the basis of quantum merit or not, that is a question which the arbitrator can very well decide. If he doesn't decide, you have 34.
That's one
But
part.
that cannot be a reason out here for this court to condone the delay.
That's one part. The second part will not for my lord's consideration, will not, and that will be my humble submission. The finding of learned single judge that it was my fault, that there is an admission on my part. My submission is, my lord, selectively, my lord, one particular document has been taken into consideration out of context.
You knew it in 2024, 23. You should have challenged it and then
My lord, but my lord, if the delay can be explained by the sequence of events.
delayed
My lord, Isha Bhattacharya's case, lordship,
Huh?
please consider Supreme Court judgment in the Isha Bhattacharya's case. Wherein the principles were laid down, my lord is familiar with that. So, my lord, that pragmatic approach. But I'll just, my lord, the few
This-
principles.
So here the pragmatic approach we have considered.
So, my lord, one, I'll just place the relevant in Isha Bhattacharya. My lord. 21.1, 21.2, 21.3, and 21.4. Paragraph, 21, the principles laid down. So far as confirmation of delay in the writ appeal is concerned.
21 point.
21.1, 21.2, 21.3, and 21.4. That would be my humble submission, my lord may consider. Because the findings, my lord, the manner of recording the findings, of course, my lord, it is true, we ought to have the immediately in the writ appeal. For some good reason, my lord, that course of action was not adopted. But my lord, we were not sitting idle. Lordship, at least will have.
No, you were not idle means a right has been created in the meantime on that. That is the basic reason why you have the Limitation Act.
Also, we are not saying that we should be given the, we don't say, we are only in respect of the findings recorded at BRA, only that much. We would not seek indulgence of my lord to interfere with that very portion of the imputed judgment, wherein the law, the termination of contract has been held to be legal. Let that remain untouched. Lordship may not interfere with that. Let there be another party executing the contract. But to say that we are at fault, that we have admitted our fault, that cannot at least.
And there are many judgments also of the Supreme Court. So we can't look into the merits. Things we condone the delay. But the fact that what you are saying is that look here, this was a judgment passed to that effect, you were not. We will look into only to the aspect as to whether there was any liberty was granted. Liberty was not granted. The court concluded it. That is why I asked him, as to, did you not raise that there was no issue? There was no arbitration dispute because the dispute had already culminated. But he has not raised, all these objections were kept open.
With due respect, no. Unless they file an SOC, statement of claim before the arbitrator, then only, my lords, the final claims which are being made by him will be crystallized. So that is why, my lords, while appointment of the arbitrator was being done, liberty was granted to raise all objections whatsoever. But, my lords, my right to raise objections arise only when he files his SOC, statement of claim, in which he is, my lords, relying upon that seeing that the termination was invalid. His claims are that the termination was invalid. Due to the illegality in termination, I have suffered these many damages. Please grant me these many damages. My submission before the arbitrator was after he filed his SOC, because the occasion did not arise for me before he files an SOC. That see, now he is filing a statement of claim under which the claims are surrounded are surrounding the aspect of the validity of termination. So he cannot now touch upon the validity of termination in his statement of claim.
And Mr. Counsel, Vidya Drulia says that as regards the aspect pertaining to whether there exists an arbitration clause or not, the court can very well look into it.
Yes.
And therefore, he has raised it and said that he must have 100% stated in the application which was filed to those, in the representation of the notices which have been issued, that this is my claim or what I want. And as such, these are my claims, and and as such, we wish that the matter be referred to the arbitrator. You having not done so in terms of section 11.3 or 11.5.
BLT judgment and Soma and a statement of Supreme Court says that while appointing an arbitrator, or what the appointing must designate of the Honorable Chief Justice of a High Court can implement. They say, only those claims that are ex specified, not maintainable due to limitation aspect, ex specified, if it touches merits of limitation, etc., then also High Court has to hold its hands, and High Court has to relegate the entire matter before the arbitrator, not enter into merits of a claim, maintainability of a claim otherwise.
No, understood. There's no quarrel with that.
It does not
So
mean-
therefore, you did not. We say that you have not raised. Have not on that whether the res judicator will apply or not. So you did not raise any objection to the appointment of an arbiter.
But number one, he has to show whether in his petition before the Honorable High, he mentioned this fact. Because my lords, he filed this writ petition before the Honorable Gauhati High Court, which was rejected in my lords, June 2023. He filed this petition before the Honorable High Court, a different High Court lord, but the counsels are also different lords. Now, lords, in that petition, he filed 1.5 years thereafter. And whether he stated this fact clearly, and whether he brought to the notice of the Honorable High Court, the onus is upon him. Secondly, if I raise this objection before the Honorable High Court at the time of appointment of an arbitrator, it would have been a premature objection. Because my objection is not with respect to the jurisdiction of the arbitrator under section 16. Because there is an arbitral clause. So the arbitrator has to be appointed. But what are the disputes? Whether they are otherwise maintainable, in law, is to be seen once he files the claim. Suppose he does not file the claim for termination law, invalidity of termination or the damages, alleged damages arising out of the termination. I had no occasion to object before the Honorable Arbitrator. It's only when matters of plaint, for example, a plaint is filed before the civil court, and I'm filing my WS only on the basis of the relief sought or the cause of action pleaded, only then I can take an objection.
Mr. Counsel, but Mr. Counsel,
so I did not miss the bus.
Whether the filing of a plaint can be a proper metaphor, taking into account that the arbitrator is appointed, or is both the parties together appointed, or the arbitrator is appointed by the court. Whereas the plaint, you can very well go and file it.
Can I say something? Actually,
only one point. There is one important aspect my esteemed colleague forgot to mention. In his statement of defense, he did not raise the plea of res judicata. The plea of res judicata was taken 5 months after filing of the statement of defense, only on 15/4/25. Yes, only on 12/9/25.
No, it is, Mr. Tiwari, that is the wisdom of the arbitrator to accept a belated plea being taken or not. That is a different thing. I am not on that. I am not on that. But the fact remains, you knew about this thing. Can you say that tomorrow we had no knowledge about it? My only question is, did he file an objection before the court? And did you also mention that there was a dismissal of the suit of the writ petition before the learned court, Delhi High Court? Because these are questions which are looked at. We are seeing on an equitable basis. Now, what are that? You cover from the facts which appears out here. A termination happens. You come up before this court challenging the termination. I have not seen the writ petition. If we see a copy of the writ petition, if it is there anywhere.
Next,
Where?
this man on the point, page. Page 28 to 370.
Page?
Page 38.
Of the writ appeal,
38.
of the writ.
Volume 1.
So you didn't ask for any money. You didn't ask for any damages. Your specific question was as regards termination, legality of the termination.
Therefore, crystallization of rights are concerned. They are not saying that we should tell about the work now.
No. Whatever may be, the legality of the termination has been upheld by the learned single judge. Now, after it has been upheld, did you inform it to the Delhi High Court when you filed the application? You didn't find it necessary. You have to be taking into account that if you want this court to condone the delay of 35 days. Now, if you have raised that issue, the Delhi High Court would have considered, because a perusal of the entire order of the Delhi High Court, there is no reference about filing of any writ petition before the High Court. That is not there. Whether he raised any issues, what was his counter in that proceeding before the Delhi High Court is not known. As to whether he had filed a counter or not filed, another aspect of the matter. But the Delhi High Court says that all objections as regards jurisdiction and everything is kept open to be made before the arbitral tribunal. Now, thereupon he files and you go to the arbitrator. After then also you don't realize in law that there is a termination which had been legalized. And now can you take a plea out there that kindly hold that the termination is illegal? Impossible. As per the registered litigators.
Because my submission is, I am not on the termination of contract itself,
No, the basis, but Mr. Tiwari, your basis for the termination of the contract or basic for seeking the condonation of delay is, look here, he raised the issue of arbitration, therefore the court did not go, the court went into and decided the entire thing. Thereupon we initiated the process. After that, arbitrator has been appointed. We never knew that he will take up the point of res judicata. When he, for instance, filed a statement of defense also, he did not take that point of res judicata. But later on, after 5 months, he takes the, and therefore we are before this.
That's one way of looking at it. We consider the other side of it. On the crystallization of right, I only submit. Since we are at this stage, we are certainly not on the legality of the order of termination by law. We leave it totally untouched. It's only the findings of facts, recorded by the single judge, holding us guilty, holding us responsible, because that would come on our way in seeking the required.
So the question is, you have to blame the lawyer. Initiate the bar council proceedings against him. Then only the period which has been mentioned and pay of 835 days seems to be similar to the 832 days, which is a case of, I think, 1998 IUCC, where the Supreme Court said that no, unless the Supreme Court condoned the delay because of the fact that the Bar Council has imposed 50,000 upon the lawyer in 1998. We are concerned out here in 2026, so unless 20-25 lakhs be imposed upon the lawyer, and then we can consider condoning the delay. This is not that way, because it is either you did not get a good legal advice. That might be the only reason. But you cannot say out here to the effect that you did not know all this while and you never thought that he will raise that point. Hurry. Can that be a ground for condoning the delay? People will laugh.
was a long approach of.
It's not the wrong approach. Wrong approach you adopt when your lawyer makes this mistake.
True.
So you have to, your only way is the lawyer mistake. And that is why
The way you know the proceedings were
98
initiated by the High Court.
97 SCC. 97. Yes, I said 98, 7 SCC, 1, 2, 3. There, 883. Here you have 835.
Which, I'm sorry.
1, 2, 3.
1, 2, 3. But you know,
So there, at that point of time, 50,000 was done. So it is good. We are in 2026 where the value of the rupee has gone down.
that is what aspect, still earned for a lot of consideration.
It's a very
That
difficult
we
thing,
are-
Mr. Tiwari.
The findings recorded, because findings.
You see, you are placing before us judgments of 2013. Now the law, recent judgments are different, very categorically. If you see the judgment of Justice Pardiwala recently on the issue of there to that effect, wherein he says, yes, Ram Kumar Chaudhary. So that judgment is there. That is one judgment wherein it says not only you need to explain the fact that why you did not file the appeal within the period of 30 days, which is provided, but you are also after 30 days. But you are also to explain why within these 30 days also you could not file it. Now, this is the strict, more which it is. I think now with the time, well, litigation is the litigation has become so expensive, time consuming, all these things. It is the mandate of law also in public interest to keep it that these type of matters. Yes, if it is a pension matter, I would have considered 835 days. Isha Bhattacharjee happens to be something to their effects. But not in a contractual dispute where you are asking for 47 crores or 50 crores to that effect. And they said, look here, where is the question of making payment? You have your termination is already illegal, held in 2023, and we have never approached this court. Very difficult because here, the basic idea behind the Limitation Act or basic principle of the Limitation Act would do. Very difficult.
So, just have some discussion about it. I'll just find out something.
You find out something next week. I'm not going to condone this delay. Very difficult.
Yeah, up to 9 minutes, I'll just, I will not be asking for next week.
We'll take it up we are taking up at 2. Okay. Very difficult.
Immediately after, because possibly may. Will be for 5 minutes, not to be discussed normally, my not does.
I take it, but that time is already lapsed. Normally, I take it at 12 o'clock.
Maybe after one matter, I'll just hold a consultation for the short while.
So Mr. Tiwari is in a rush to go back to Gauhati.
I have to come only for this. Immediately after the next case,
Okay, let us see.
For orders, item number 5.
Oh, this matter. Where is the other side? Nobody is appearing. What is the case? Let us see.
Yes, my lord.
Yes, what is your case?
Yes, my bill before my lord. My lord, this initially, my lord, is petition was sought, my lord, in the nature of habeas corpus petition, my lord.
Hmm.
Now, my lord, because of subsequent developments, my lord, nature has changed, but issue remains, my lord, something more, my lord.
Huh?
Petitioner to my lord has been released, my lord,
So there's
by a
nothing.
reference of this honorable court, my lord.
So here nothing remains then.
No, my lord, still some issue is here, probably, my lord, because
No, then any other issue. You see, a habeas corpus is different. Now,
yes,
habeas corpus is when a person is not being traceable or anything, you ask the officer out here to make or direct the officer to produce him. Or if it's a case of illegal detention, so that that person is produced before us. That's
yes,
the idea of habeas corpus. Now here the person is there. He's not in custody. He is very much available. He
absolutely,
or she is very much available, isn't it?
yes,
So therefore, any other issues, we give you the leave to take up by way of a separate petition, not by way of a habeas corpus.
no, my lord. I appreciate, I can understand what is falling from your lordship, but my lord, only thing is problem is, my lord, the court has to determine whether I have been legally detained or not. That has not yet decided by the court whether I'm legally detained,
So,
illegally
so, so,
detained.
so, no, no, then it is a case of compensation. It's a case of a constitutional tort. Your case is a person who is
Absolutely, my lord.
below the age of 18 years, who is a juvenile. He cannot be detained against the various directions passed by the Supreme Court as well as the Juvenile Justice Act. That's your case. And if there is a detention which was there, that is a wrongful detention, and therefore you can very well ask for a constitutional tort asking for a certain amount. So
Absolutely, my lord.
that's a
But
different aspect of the matter.
lordship is quite aware, but I'm not bringing for any compensation. And for my lord determining the issue, court has to first, my lord, see whether I'm juvenile or not, in order to determine whether there is illegally detained or unlawfully detained.
Mr. Counsel, if the court does not do it, when the point is being raised that the court does not do it, then you have a point of law which can be very well taken up. But in
But
proceedings under revision or something, you have to take it up.
absolutely,
Why
lordship.
should we
But
exercise a writ of habeas corpus for this?
Lord, already court below, my lord, what happened is, my lord, the court below has conducted an ossification test, my lord. The learned JJB, my lord.
What did he do?
Conducted an ossification test, my lord. And as per the ossification test, my
But
lord, report, my lord.
Mr. Counsel, there's a judgment of the Supreme Court which categorically mentions what are the first things which are required to be looked into. If there is a date of birth or all these things will be looked into, and if it is the last resort is that test, isn't it?
Exactly, absolutely, lordship is correct.
That is the judgment of the
Absolutely,
Supreme Court in that regard.
absolutely. That is what I am relying for, my lord.
Ah. But they having done so, you can very well point out that aspect. What is the judgment of the Supreme Court in that regard?
My lord, I have just placed it, my lord.
Tell me, what is the judgment?
My lord, it's a judgment is, my lord, Rajni versus state of UP, my lord, another, my lord.
Rajni versus State of
UP and another, my lord.
UP and others versus reported in
If, my lord, 2025, my lord, 0,
huh?
supremacy
No,
876, my lord.
no. In fact, I have also delivered a judgment on this point. Though I don't take up
Yes,
criminal, it's a
yes,
different
my
thing.
lord.
I'm back
It's a,
on it.
it's a, my lord, landmark
I
judgment,
have,
my lord.
huh?
It's a landmark judgment, if I may say, my lord.
Rajni
Very good
versus
judgment.
Very well, you give a good certificate. Two thousand 25, na?
Yes, my lord.
The judgment by Justice Bhuya,
Yes, my lord.
isn't it?
Yes, my lord. Honorable Justice Ojar Bhuya was one of the bench, my lord.
He has delivered it.
Yes.
But
Justice Oka was here, my lord.
But there is another judgment apart from that, which holds the point on.
That is regarding Bosco matter, my lord. I have that, my lord. I have not, my lord. I'm sorry, my lord. It's a, my lord. It's a decision in my lord. That is, my lord. One of the judge, my lord, Justice N.K. Singh is here, my lord. Justice Sanjay Kaur, my lord, and my lord. It's a guess, my lord. State of other British versus
Paragraph
Home Rule in
23.1.
another.
Mr. Counsel,
Yes, my lord.
23.1. Therefore, the same is extracted in every case concerning a child or juvenile in conflict with law. The age determination inquiry shall be conducted by the court or the board, or as the case may be, the committee, by seeking evidence here. First, matriculation, then date of birth, then birth certificate, and in absence of one above, the medical opinion will be sought from a duly constituted medical board, which will declare the age of year. In case of exact assessment cannot be done, the court of the year, as the case may be, for reasons to be evident, may with consider give benefit to the child, and while passing orders in such and so on. So paragraph 21, 22, isn't it?
My lord.
Yeah,
My lord, para 28 is relevant, my lord.
Paragraph 20.
It discussed section 94.
Admittedly, the line of reasoning adopted by the JJB is totally fallacious, isn't it? That is the paragraph.
Paragraph, yes, lordship.
Application claiming other. I think this is here, it's different. The Supreme Court dealt with in Rishipal versus here. I think this is the judgment. Rishipal Solanki is the main case. I think that is the main judgment on this point.
Yes, Rashiva Singh, that is the main case that has been referred here in para 31.
Because that is the judgment which duly takes note of what are the requirements to be done. In fact, it categorically lays down those paragraphs 33, 33.1, a claim,
Yes, my lord.
application claiming which could be made either before the board or JJ board, so and so, so and so, so and so. The presumption is, however, not conclusive proof of here. So we do one thing.
Yes, my lord.
We disposed of the instant petition saying that you are no longer in custody, and as such, the prayers have here. However, we direct the court to duly take note of the judgment of in Solanki as well as this judgment, Rajni, and proceed against the juvenile in accordance with the law.
by setting aside, my lord, if I may add, my lord, by setting aside the ossification test. Otherwise,
Why should we set aside now, as of now, are you still, you are no longer a juvenile?
I am no longer juvenile, my lord.
So now you are no longer a juvenile. So therefore, we only say that the court shall duly take note of these law before applying the medical board test.
Yes,
I think that would be sufficient for you to take it up in the trial,
yes.
isn't it?
Otherwise, court below cannot have power for review.
But Mr. Counsel, you have taken you have combined a lot of things into one matter.
Yes, that is some technical problem, my lord.
Very technical problem.
That's why I have placed two judgment regarding the alternative remedy, my lord, judgment. Lordship is quite aware.
No, but on one hand, he is in illegal detention. Detention is over. That man no longer there. But you are also raising on the issue of the test, the medical test, which was being conducted without looking into the other documents which are necessary, documents which should have been taken into consideration in terms with the two judgments. So therefore, we dispose it off in that manner. Okay, sure.
All right, my lord.
Actually, there was no detention order. There was no detention order actually. He was
And only problem is, my lord, they have taken Aadhaar card.
This is illegal detention, but then he is challenging the rejection is there.
But have you changed the certification process?
That was true. This challenge the improvement and the rejection in both the determinant.
Mr. Counsel, show me the order which you have challenged as regards the ossification test.
Page 84, my lord.
Page 84. Where have you challenged 7.3?
7.325, my lord. Ossification test, that part also I have challenged, my lord.
No,
Entire proceeding.
where have you challenged the order of 7.3?
My lord, may kindly see my prayer portion.
Yes, where?
Prayer also I specifically made, my lord. Last prayer, my lord. Page 43, my lord. Prayer number 4, my lord.
Where is it? 7.3?
7.3 is okay. As well as impugn order dated 7.3.
Where is the 7.3 order?
Annexure 9, 7.325, passed by the London JJB
Oh.
via Annexure 9.
That being used, that being the case, and as per these no matriculation certificate, nor certificates from the school, because attended also ensure to prove the age of students of the to seek medical opinion. Now here there is a finding of the learned trial court. That being the case at 7.3, that being the case, and as there is no matriculation certificate, nor certificate from the school he first attended, or any municipal authority to prove the age, upon deliberation by the members JJB, it is found proper to seek medical ossification test. Then what is wrong with this?
Now, my lord, kindly see earlier order of the session court, my lord, special court, my lord.
Page?
My lord, kindly page, my lord, page 80, 11 to 25.
Yes.
Last page 80, my lord, last line, lordship may see, last paragraph. It is submitted, it is being submitted that accused state of part is so and so, and as such, the accused was minor on so and so on the commission of alleged offense. Since
So
the
where
birth
is
certificate,
so where is your birth certificate?
kindly birth certificate, Aadhaar card, which indicates so and so, so and so. Now, my lord, kindly see my birth certificate, my lord, kindly see page 54, my lord. Twenty-two 1/2008. The Supreme Court.
So this was not taken into consideration.
I- My lord, if I may say so, my lord, it's very harsh for me to say, my lord. Learned court below even not does not hurt me, my counsel, my lord. And but observation test was all proceeding was past ex parte, my lord. When my counsel filed a petition, my lord, and when the matter has been referred by the learned special court, my lord, to the JJB, he should have been notified, my lord.
But
It's all
tell
fair
me,
process.
no. So therefore, when the matter was before the judge initially, special judge,
Yes,
he
my lord.
took note of that there is a birth certificate,
Exactly, my lord.
and thereupon refers it to the juvenile board.
Yes.
Juvenile board on 7/3/2025 do not take note of the birth certificate and direct an ossification test,
Yes.
isn't it?
Yes.
So therefore, you are saying that the ossification test should not be taken into consideration.
Yes.
Unless
Yes.
the juvenile board came to an opinion that
Yes.
medical certificate which was issued earlier was not, or the birth certificate, made an inquiry as regards the birth certificate and came to an opinion that the state is fake, isn't it?
Absolutely, my lord. If my lord, if the concerned JJB has any reason doubt, he should have conducted an inquiry. But in no circumstances, he cannot, my lord, override, my lord, because once there is a birth certificate and a school certificate, other documents are there. So clause section 94, clause 2, Roman 1 and 2 is very clear. Unless those documents are not available, then only ossification test could be carried out.
Now, Mr. Counsel, tell me,
Yes, my
if
lord.
order was passed on 7/3
Yes.
and you approached this court then,
Immediately, my lord. Because
and was there a stay? No.
immediately on the first day of motion, my lord, I am on interim released by this honorable court.
You were released.
Yes, my lord, by this honorable court. Lordship may kindly see the first order, my lord. Order dated, my lord, kindly see 36/25, my lord.
So you are being granted a bail by the court.
By this honorable court, my lord.
But
Because even after statutory payroll, my lord, of my lord, 6 months, my lord, as per since it's involving, my lord, NDPS Act, my lord, offense, my lord. So even after statutory payroll, court below has failed to, my lord, enlarge me on default bail, my lord. So, my lord, my illegal detentions still continue, my lord, from the date of remand. Because once a plea is made before the court, when deal decision arrived by the court below, accused that a person claiming to be a juvenile cannot put behind a bar. He should be in the observation home or something like that, my lord, as per the act.
whether they first became more for language to the It has to be as part of certificate of the but of municipal body. Now the register of dates and births and register of living the certificate. But that is the third document this is statement.
Of course, it has to be the interpretation. Then this one comes.
You see, that you know, these are first. One person next.
Number one is an interpretation certificate. That is not there in the birth certificate.
It is a person who is there. So why they have written the
Why the need for certifications?
Look, once this is there, in absence of a birth. In this regard, you see what we find, one thing. The person, at the time when the reference was made to by the special judge to the juvenile board, it was categorically mentioned about the birth certificate. The special judge NDPS categorically records seen the birth certificate. In the birth certificate, the age which has been given would be around 17 years, which is this document at page 54.
(22-1 to 2008).
And the date on which the order was passed was on page 11/2/2025. Okay. If it is 11/2/2025 and 22/1/2008, then he will be around just 17 years, 1 month or something to that effect. Okay. So as on that day, this certificate was shown. He claimed juvenile. The moment that is being done, how could he be in custody of the police?
Says that he was arrested with.
This is different. That is a different aspect from whatever he has done. First of all, then you have to take a decision that he has to be tried as an adult. That decision has not come. So therefore, now the question is, the matter goes to the juvenile board. Juvenile board says that there is no birth certificate. And therefore, goes ahead and passes an order for ossification test. Ossification test has been conducted wherein it is found that he looks to be 18 years in age. The Supreme Court says that ossification case is the third or the fourth category you have to go to. First, it is made clear, you look into the school certificate. Second, by the municipal authority. It is only in the third, when you don't have those, you go for this ossification test. Isn't it? Now, main problem is that order of 7-3 is bad. There's no quarrel with that because it is perverse. But another thing is, as he has been now released on bail by this court. Could it be a case of release on bail in a habeas corpus matter? Because we are not exercising the powers under 439. Or for that matter, any exercise of power in terms with 36 of the NDPS Act 36A. What we are exercising out here is a constitutional power as regards whether to get hold of this person, whether he has been illegally detained or not. So we have to hold the detention to be illegal because that document was not taken into consideration. And therefore set him to release. It's a different thing. You want to catch hold of him, that's your lookout. We are not concerned. Yes, Mr. Counsel.
Yes, my lord.
Where is he?
Yes,
No,
yes, my lord. Yes, my lord. I'm there, my lord.
very well.
Yes, my lord. Yes, my lord. I'm sorry, my lord. Let prorogation, my lord. I'm there, my lord.
Okay. We take it up again at 2 o'clock. Yes, Mr. Tiwari. Yes.
In view of whatever has fallen from an option, you would only have
Mr. Counsel, Mr. Muri, you keep your volume down. I'm hearing the other matters. Switch off your microphone.
Mute, keep it in mute.
all the three submissions Bala will consider, that's all, and we accept everything that is fallen from an option. Number one, we completed 41.43% of the work that is reported by lender signature in page 49. And that is not the part of prayer in the petition. So our submission is that is not covered by the university judge, which is the number one. So at least the whatever work we have done, the money for that before the arbitrator, we should be allowed to raise that claim. And we have raised it. Number one. Number two, the plea of res judicata, the belated filing of the plea of res judicata, we part by 17 to all these issues are open before the learned arbitrator. We raise those issues. So that is second submission. The third thing, I can only reiterate, though I know the fate accomplished. Namely, we don't seek to disturb the vested right of the third party. We do not seek to challenge the legality of the order of termination. We only that part of the judgment wherein the findings are recorded by selective reading of the document that we are at fault, only that part should be considered in isolation and nothing else. And with all this,
Mr. Tiwari, two things. First of all, we are not a buster bomb to penetrate through the limitation wheel and go inside and look into the judgment. That's a very difficult thing. Secondly, as regards all these things are open before the trial, before that court, before the arbitrator. We can't look into those aspects as to whether a case of res judicata is made out or not. It is the difficult thing. We can't say whether it is made out or not. And I don't think that would be proper on our part to make an observation to that effect as to whether a res judicata is made out or how far the res judicata would apply qua your claims which are being made. You may be asking for certain money. The money would be many things. Yes, there must have been a termination. If there is a termination, the amount which could have been deducted as per the termination is a case by which they have to come out by filing a counterclaim as regards the payer. But without a counterclaim, whether they can do all these things, these are absolutely within the realm of the arbitrator. So, but the fact remains that asking the order to be passed out here would become difficult for us, taking into account the settled principles. You knew it everywhere. But only problem is once we do that, we may have to make certain observations here and there which may affect you somewhere. Only worry is that.
Sometimes we not by our powers of great do act as bunker busters.
Huh?
Sometimes not by our powers of great do act as bunker busters. So I'll only have to one compassion. There is a catch-22 situation, my hands are also tied.
No, catch
And
22.
certainly-
No, so the only plea which you could have taken was a not proper legal advice. That's the only plea. And because of a legal advice, you had to proceed in a particular land, and he gave that advice that there is no necessity, and therefore we never thought. And therefore, when he raised this issue, it came up. That is a plea which can only be taken into consideration.
That liberty is given by my lord. It was there, I know it for sure, I have asked these questions, specifically asked these questions. But not at the same time, there is a well-known maxim, ignorance of laws no excuse. Goes both ways. If need to not, we are willing to amend our IA, we are willing to say on affidavit that we were wrongly guided in the whole case from the very beginning.
That's your call. If you want the leave, we are not going to give you. You ask for time, you want to file an additional or reply to the affidavit or file an additional affidavit.
Submissions are made at bar.
Mr. Counsel, I don't think you will dictate how this court functions or the practice or the procedure this court functions. That might be a thing in any other court, not here. This is, I would have understood if the arguments are being made in the main matter on merits, it's a different aspect of the matter. But here we are considering as to whether a case of condonation of delay. Yes, the Supreme Court has made it very clear, condonation of delay has to be taken up in a more liberal approach. But liberal does not mean destroying the rights of the other person which have accrued. That is the fundamental aspect. So therefore, the pragmatic which was there in 1998 or 2011 is a different pragmatic in today's world.
This is particular speaking very interesting. You can see my lord has explained the legal principle. There is a simple, I have to accept that. I pray for time, and file an affidavit explaining the idea, I'll add few paragraphs. I'll write or oath that wrong legal advice must be.
That's your lookout. I'm not here to guide you. I'm not here, but you could only come. And you see, barely saying wrong legal advice would not, because the moment you have come to know when there is a long legal advice, have you taken any action? You see the judgment that were, therefore I'm saying 1998 7 SEC, page 1 to 3. Have you got it, Mr. Counsel? The 98 7 SEC. There the judgments categorically says the 883 days was condoned only on the ground that action was taken against that advocate, where the consumer forum has also passed an order of imposing a cost of 50,000, if I'm not wrong. So these.
I think we don't be different from that also. I will not file this application. I want to pass. That's nothing more. I think they will be difficult to do.
So therefore, it has to be to
I
the.
know. As a lawyer, we have our limitations.
So therefore, I think that is the only way out. But you will have to. That way is also has certain curbs.
Okay.
So we will pass the order.
Okay.
May it please, Lordship. Lordship, I beg to mention item number 25.
Yes.
25, can it be allowed in the next week? That is on 10th June? Because it may not reach my lord because today.
What do you say, Mr. Takamatsu?
I've no objection. This is the interim order, so the interim order.
There's an interim order?
Yes, under for orders.
Then what is there, madam? Yes, in
Appeal
favor of
for-
my understanding.
The council appearing on behalf of the respondent seeks for an accommodation. Accordingly, list this matter on 15th of
10.
July 2026.
My lord, can it be, my lord, 10 June, my lord?
Next week.
Why?
Next week.
No, you
Uh,
can't. 10th of June,
on
not possible. The judge is only coming for 1 week.
Yes, my lord.
17th.
Then July, somewhere in July.
There's no urgency on 15th.
Yes, my lord.
Huh? You said it is until further orders?
Then-
But okay, interim order passed earlier shall continue till the next date.
Yes, my lord.
Then this one is. No, no, no.
Yes, Mr. Angami, what do you say on this?
With the new case and make it like a two so at the Wednesday, but I think it's premature to approach this one. Because as far as the decision of the board is concerned, they have to overcome, the petition has to overcome section 101 of the development. And after that, if they are agreed, as my lord was observing the initial stage, they have to come in the form of revision, under section 102. And
No, that is understand.
Yes.
No, now the problem is there for this court also. You see, we have granted a bail.
yes,
Now, can we grant a bail if it is a case of in a proceedings under 226? We have granted this bail. If the detention is held to be illegal, then the question of bail does not arise. It will be an illegal detention.
actually, they have come under not many sections. Only 6 one was accused, section 102 and the office.
No, I'm not on that. My question is, if he's a juvenile, then obviously you cannot put him behind bars. He has to be in some home. That is what it is. Now, if he is put behind bars with the police, then it would be an illegal detention.
Oh, yes, that is true, but the issue still remains whether to prove whether he is a juvenile or not. So unless.
So therefore, the question is,
Yes.
the order which was passed by the special judge categorically mentioned that there is a birth certificate.
Yes.
Whereas the order which was passed on 7/3/2025 by the juvenile board, they don't consider the birth certificate, which is a requirement of law, and go into the ossification test.
Yes.
Now, ossification test is wrong, could not have gone into unless the juvenile board came to an opinion that this very certificate is wrong. They cannot have regarded the Aadhaar card. Aadhaar card is only not even for citizenship. Supreme Court have also said really recently, Aadhaar card is only an identity. It does not say as regards his age also. So therefore, and when the Act as well as the rules makes it very clear that first you are to look into the school certificate, second, the municipal body or any corporation certificate, and then if these two are not available, then you go for the ossification test. Was it proper on the part, if we set aside 7.5, if we set aside today's 7.5, the consequences is the ossification test goes. Then we have to ask the juvenile board to again look into that. But would it be proper on the part of this court? Now the problem otherwise was not the problem. The court could have very well said that now he is no longer there, so habeas corpus is not there. What he did, the counsel out here, he mixed everything together and filed one writ petition, which he should not have. Now we cannot hold we cannot say that if he is being granted bail, means he is considered to be, the question of illegal detention has not been considered.
Yes, the thing is, if he's aggrieved, still he has a remedy, section 101, against if the petition is aggrieved by the decision of the court, by the order of the
No, then what do we do as regards his bail?
and even that, now they have come under 226. They have also have to prove that they have come for this on for the clean hand. Because application for extension under section 36, the PP has petitioned for extension of 1 year. Now they have the application of the service court was already submitted to the case. But the council never appeared, the order self says.
For extension of time for investigation.
Yes.
Sure.
To overcome that statutory period.
The moment we close the petition that we accept, the bail order which is there will always would be there is a bail being granted by the court. Now, if the bail has been granted by the court, it means he is under the detention of the police. He is in the detention of the police. The next question is, he is asking for to say that detention could be illegal.
That's what he said. He said that it's illegal because he's a juvenile.
Actually, now without that, I will be very careful. And in the entire case, the moment we say that the bail is okay, then the detention of juvenile is
Look at you. This thing.
the point that I will. Sport should not be issued any benefit of bail. We have the house for that immediately initiated. I think the bail makes taking.
That shows that he's been in the custody of the police and so he was.
Actually, I should have directed them to look into that and verify it. We do one thing. We in the interim interfere with the order of 7/3/2025. Okay. And direct the juvenile board to look into it on the basis, as he is already on bail, and thereupon to submit a report before this court, for this court to decide as to whether the detention was illegal or not. Then we can very well later on come up and say, if he is considered on the basis of that or finds that particular birth certificate to be okay, then in that case, we can birth certificate is okay, then he is a juvenile, so it is an illegal detention. So therefore, we close it and hold it. Now he is not there. So the illegal detention, it will be a detention. So the question of bail does not arise. We can close it in that manner. That appears to be the right approach.
I think that's better.
We set aside that order of 7.5 as well as the ossification test. We set aside that and direct them to again decide, make another report on the basis of this certificate.
That sounds very good. Observation, but I don't know that will overcome section 101.
Huh?
Section 101 of the GK.
No, understood. But you see, the problem which is this court could not have granted the bail at the first instance. Now, the moment the bail is being granted, it is being held that he was in the police custody, he is given bail under 36. Now, the bail once is being granted, it is legalizing his detention. It is legalizing his detention. So therefore, once it is being legalized, if we just close it on the head, and the moment we close this petition without an inquiry into that, then what happens? His entire plea that he is a juvenile goes for finished. So therefore, the only way we seem is practicable or more pragmatic is interfere with 5.3, ask them to look into this. The ossification test which has been done will remain as it is, but if it is found out that on the basis of these, taking into account these judgments, that they were required to look into this, then the test will go, and then the detention will be illegal and the matter can be finished up by any other court.
That is a best option. Very another is okay.
Okay.
Another good option.
Heard, Mr.
My lord, may I just supplement, just my lord?
Don't
Just
submit.
one supplement, may I just?
No more submission. N.K. Muri, the learned counsel appearing on behalf of the petitioner.
Just to avoid the complexity, my lord.
Huh?
Just to avoid the complexity, my lord, my lord, if I may allow permitted to supplement, my lord.
Yes, submit.
My lord, what lordship has indicated, my lord, at the first instance, I also, my lord, acknowledge, my lord. If, my lord, that order is set aside, and let me, my lord, pursue before the concerned court, my lord, to determine the question of juvenility afresh.
That is what we are
That will be
passing.
better, my lord.
Mr.
Yes, my
Counsel,
lord.
this is what we are passing also. You listen to the order. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Kiangami appears on behalf of the respondent numbers 1 to 6. 1 to 5.
1 to 5.
1 to 5. Who appears for 6?
No.
Okay. None appears for the respondent number 6. The present petition has been filed by the mother of one Mubarak Ali, challenging his detention on the ground that her son was a juvenile. The petitioner, apart from the above, have also assailed the various orders by which the default bail of the petitioner, of the son of the petitioner, was not granted, as well as the order dated 7/3/2025 passed by the respondent number 6. This court duly takes note of that the son of the petitioner was arrested on 15/12/2024
16,
15, na? 15, 12, 2024.
16, 12.
16, 12.
Yes, my lord.
The FIR is of 15,
Yes, after one day.
was arrested on 16, 12, 2024. In connection with a case registered as WOCA PS case number 047/2024 under sections 22 capital C oblique 21 small b of the Narcotic Drugs and Psychopathic Substances Act 1985. The petitioner, the son of the petitioner, Mubarak Ali, was produced on 24/12/2024. And he was sent to custody, judicial custody, na? Thereupon, on 11/2/2025, the matter was taken up by the special judge, NDPS WOCA, wherein a plea was taken by the son of the petitioner that his date of birth was 22/1/2008 and the date of commission of the alleged offense was on 16/12/2024. The learned special judge, NDPS WOCA, also refers to a birth certificate as well as the Aadhaar card of the son of the petitioner, and therefore referred the matter to the respondent number 6 to ascertain the age of the son of the petitioner as per the procedure provided under Rule 12 of the Juvenile Justice. What is that full name?
Lord, Juvenile Justice within bracket Care and Protection of Children Act 2015, my lord. Amended rules, my lord, 2022, my lord.
Juvenile Justice bracket Care and Protection of Children Rules 2007 as amended in the year 2022. 2007. The records further reveal that on 7/3/2025, the respondent number 6 took up the said aspect pertaining to ascertaining the age of the son of the petitioner and observed that there was no matriculation certificate nor certificate from the school where the son of the petitioner attended or any municipal authority to prove the age of the son of the petitioner, and under such circumstances sought for medical opinion on oblique ossification test to determine the age of the son of the petitioner. The resultant effect, pursuant to the said order, the ossification test was carried out by the Naga Hospital Authority, Kohima, and it was opined that based upon radiological findings of the X-ray appeared that the son of the petitioner was above 18 years. On the basis of the said report of the Naga Hospital Authority, Kohima, The respondent number 6 sent back the case records along with the documents oblique materials received to the learned special judge oblique session judge Woka for necessary order. The record further reveals that the application so filed by the son of the petitioner, by the petitioner, as regards for release of the son of her son on the ground that he was a juvenile at the time of commission of the offense was rejected by an order dated 21/3/2025. Subsequent thereto, a bail application was moved before the learned special judge Woka for grant of bail for grant of default bail. However, the same having not been, no order having been passed in that regard, the petitioner had approached this court by filing the present application. We also find it relevant to take note of that by an order dated 30/6/2025, the learned coordinate bench of this court granted the petitioner default bail on the ground that the charge sheet was not submitted within the period of 180 days.
Interim bail, my lord.
It's an interim bail.
Yes, my lord.
Had granted an interim bail to the petitioner on the ground on the interim default bail to the petitioner. Full stop. We have heard the learned counsels appearing on behalf of the petition parties. I've heard the learned counsels appearing on behalf of the parties. We have also taken note of the judgments of the Supreme Court in the case of Rishipal, HRISSHIPAL, Singh Solanki versus State of UP, reported in 2022 8 SCC 602, as well as the judgment of the Supreme Court in the case of Rajni versus State of Uttar Pradesh and another, reported in 2025 SCC Online SC 1183. From a perusal of the said orders, judgments, it is apparent as to what should be the course of action adopted by the juvenile board for ascertaining the age of the age. The Supreme Court, in the case of Rajni Supra, categorically observed that the process of age determination is provided in subsection 2 of section 94, which is identical to the procedure prescribed under sub-rule 3 of Rule 12 of the Rules of 2007. It was further mentioned that the Juvenile Justice Board, while undertaking the process of age determination, shall seek evidence in the following manner. Number 1, Roman 1, the date of birth certificate from the school or matriculation or equivalent certificate from the concerned board, if available. Roman 2, in absence thereof, the birth certificate given by the corporation or a municipal authority or a panchayat, semicolon. Roman 3, in absence of Roman 1 and Roman 2, the age shall be determined by an ossification test or by any other latest medical age determination test conducted on the orders of the Child Welfare Committee or the Juvenile Justice Board. In the backdrop of the above, if we take note of the order passed by the special judge while referring the matter, order passed by the special judge, NDPS Woka, dated 11/2/2025, whereby the reference was made to the Juvenile Justice Board, Woka, it is seen that there was a reference made to a birth certificate, which the learned special judge NDPS duly taken note of, wherein the date of the son of the petitioner was mentioned as 22/1/2008. The same birth certificate has also been enclosed to the present proceedings, which is Annexure 3 Coli, and more particularly at page 54 of the writ proceedings. However, in the order so passed by the Juvenile Justice Board, there is no mention about the birth certificate which have been issued by the Department of Health Services, Government of Assam, bearing number 2396383, wherein the son of the petitioner's date of birth have been mentioned as 22/1/2008. First, the non-consideration of the said birth certificate and directing ossification test, in our opinion, was not in terms with the settled principles of law, including the provisions of section 94(2) of the Juvenile Justice Act, what is the name? Juvenile
Justice Act 2015.
Justice Care and Protection of Children Act 2015, as well as the rules framed therein under. Accordingly, we pass the following observations and directions. Number 1, We direct the respondent number 6, that is the Juvenile Justice Board, VOCA. Number 1. We set aside the order dated 4/7/2025, passed by the Juvenile Justice Board, VOCA. Number 2. We direct the Juvenile Justice Board, VOCA, that is the respondent number 6, to carry out the verification as to whether the petitioner, son, that is Mubarak Ali, was a juvenile or not. In doing so, we grant liberty to the petitioner to place all such documents, including the birth certificate, which has been enclosed to the present proceedings, issued by the Register of Births and Deaths, Borpeta, bearing number 2396383. We further direct the Juvenile Justice Board we further grant liberty to the Juvenile Justice Board to also carry out verification as regards the authenticity of the said certificate, said birth certificate. And take a decision thereupon. First, we further observe that till the decision is being taken by the Juvenile Justice Board on the age of the son of the petitioner, that is Mubarak Ali, the test results of the juvenile of the Naga hospital at Kohima, the ossification test results of the Naga hospital at Kohima shall not be given effect to. Full stop. A report, full stop. We direct the next. We further direct the petitioner herein to place a certified copy of this order before the Juvenile Justice Board, VOCA, on or before 10th of June 2026. 10th of June 2026. Huh? Why? For him. He has to produce.
For him to produce.
Little bit.
Because what is happening is, the moment we are staying this, it has the effect on the trial also. The trial will get stayed, na? Get the
Trial
point?
is, I hope trial is yet charge sheeted, my lord.
Very good.
Investigation.
Okay. So and so, yeah, on 10th of June 2026, along with all such documents to show that the petitioner's son, that is Mubarak Ali, was a juvenile as on the date of commission of the offense. Because now he is not. On the basis thereof, we further direct the Juvenile Justice Board to take a decision as to whether the son of the petitioner, that is Mubarak Ali, was a juvenile as on the date of commission of the offense, that is on 16, what is the date? 16/12.
15/12, my lord.
15/12/2024.
FIR date.
And submit a report before this court. Full stop. List this matter again on 3rd of August 2026. Full stop. The interim order so passed earlier shall continue till the next date.
Bail order is made already absolute, my lord, by the court below, my lord.
Has been made absolute. So there is no
Yes,
interim. Okay.
Yes, my lord. I'm obliged, my lord.
Interim order is not necessary. Oh, this is the other file. This you give it to madam.
For orders, item number 6.
Please, motion. Lordship in the different matter. Lordship, I was permitted to file a between the person order dated 18/3/2026. I was permitted by the appellate court to file a between the opposition. So our court was pleased to file the affidavit on or before 10 April 2026, and the matter was directed to this on 15 April. So in the meantime, I filed the affidavit, but since there was a defect, rejected on 22nd April, when the matter came up.
You filed the affidavit or not?
No, it is still like, I will be allowed to take my submission, but I have nowhere to hide. I have to give submission only.
Okay, you cannot file it because we have passed that order. Na? It
Yes,
was a
Lord.
special opportunity grant.
Yes. Then on 22nd, the matter came up. So since the affidavit was rejected by the filing section due to some defect, I read a 1 week time was given. So thereafter, I made some rectification. And few days back, on the Wednesday, appealing counsel about inquiry about the affidavit, I told him that I'm going to provide an affidavit. But your worship, it was like as it is in my job. So I have no way, but I have to come to your worship.
Now you say that you have filed an affidavit with
No.
certain defects.
Yes.
Where is the affidavit?
No, rectified.
Rectified.
Fine.
Oh, rectified but not filed.
Lordship, I have no way, but I just, my humble submission before Lordship is, I will be allowed to file the affidavit under such terms and conditions. I have no way. That is my humble prayer. And it is not a fault of the department, it is my fault. Because
Now have you rectified the defects or not?
Yes, now I have to compel and I have to file.
Mr. Imson, have you rectified the defects or not?
Yes.
Now are you in a position to file or not?
Within few days I can file.
Well, that means if you have already rectified the defects, it is already with you.
Lordship,
Why within 5 days?
No. There is so many documents has to be combined.
So there is no, that means you have not rectified.
All after registration, no, earlier registration was different. Because there was a rejected lecture, that's also rectified.
Okay, wait, we impose a cost of 50,000 and allow you
Lordship.
50,000?
Now, I did not shift my fault to the department. It is my fault. That is my open submission before.
So upon you 50,000. Eh?
So,
You take the responsibility for the state.
Lordship, it is not appropriate to my monthly income. Lordship. Under such terms and conditions.
Okay. You have no objection.
Special opportunity was given on that paper.
Special opportunity I have earlier said on 11/12.
Yes.
6 months have gone.
Both.
Then also they have not been able to file. Mr. Imson, the problem is we will be going against our own orders.
Lordship. Understand.
Now, why give us something to say? On what basis? On first day we say, we give you a special opportunity.
Lordship.
As a special opportunity, you have to file. Thereafter, it is not possible. That is our order. Thereupon, the matter comes up on 18/2, when the appellant is provided copy, nothing happens. Then on 18/3, I pass that order as a special opportunity. Then 22/4,
22/4.
you make a submission before the court saying the affidavit on behalf of the has been filed. However, it has been rejected due to some defects, and therefore he prays the matter be listed after 1 week. So
Yes.
thereafter also,
That
give
was
me-
my assurance. And because.
Okay, Mr. Imsong, we will pass the order as per what you say. Now tell me what order should we write?
Because.
No, tell us what the order. No,
Because-
just become we give you the position as a judge. What order can we pass now? We can't pass any order because of the fact that there is so much of opportunity granted,
Yes.
unless we impose cost.
Worship, under such terms and conditions.
10,000?
Depending on worship discretion, because debtors has no choice. But your worship, I openly assure you, your worship, that I will, that cost has been paid from our own pocket.
Why do you need? The court has dismissed the appeal. So with petition, you argue without the affidavit.
Well, I know this, the mirror case of the billing also, scope is very limited. Your worship here, I have accountability to my client, to the department. So my duty is to file a.
This court, by an order dated 11/3/2026, granted liberty to the state to file an affidavit in the instant proceedings only on the ground that such affidavit would be filed on or before 10/4/2026, and thereupon the respondents would not be permitted to file an affidavit at a later stage. It was informed to this court on 22/4/2026 that the affidavit was filed, but there were certain defects. And as such, the affidavit was rejected. Mr. Imti Song, the learned counsel, additional advocate general, appearing on behalf of the state of Nagaland, submits that the defects in the meantime had been rectified and opportunity may be granted to file the same. First, considering the fact that there was an affidavit filed earlier but was rejected, this court grants a final opportunity to the respondents to bring on record their stand by filing the affidavit on or before 17th. Possible?
Something of this month.
Huh?
Worship.
We give it till 19th. Till 19th of June 2025-26. List this matter again on or before 26th of June 2025-26. List this matter again on 22nd of July 2026. In the meantime, the petitioner appellant herein would be at liberty to file their reply on or before 20th of July 2026. It is observed that if the respondents do not file their affidavit on or before 26th of June 2026, comma, the affidavit if so filed shall be only accepted by the registry upon deposit of a cost of rupees 30,000.
For this item number 7.
Yes. How many days you are there in detention? When is the period going to be over?
Detention was passed on the 2nd January 2026.
Huh?
First order was passed on the 2nd January 2026.
22nd January 2026.
And actually, page number 23, annexure 5. After representation was filed on 5th February 2026.
So what is your ground of the grounds?
Or there are several grounds which are annexed in my petition, however, really rely on 2 grounds to also, so do
This is you are registered under which case? Arms, Nagaland security.
Section
Upa not there.
logic.
Unlawful.
No, there is not government option. Onsite and BNS. There is 7-8 in a hour also. Also in the previous officials.
Here they take note of this. Now, what is your ground of detention? What is your other ground? They have duly taken note of that you have moved the bail on so and so day,
Yes, about it.
and he is likely to be released on bail.
The particular sentence are not mentioned. In the detention order, particularly the detention order, no mention has been made.
No, that is not required. In the detention order, that is not the ground out there. The detention here, it is on the basis of subjective satisfaction. The satisfaction has been received on the basis of this communication of the commissioner. Kindly see this particular, where the commissioner here, this is categorically mentioned. Here, the whereas so and so, whereas I, the commissioner, is satisfied that in view of to prevent the accused from acting in a manner prejudicial to the security, I therefore, in exercise of the iman, so and so, do hereby order that the above mentioned accused persons shall be detained and kept in central jails here. Now, this document, are you saying that the schedule is not being given to you?
Schedule is provided.
So schedule, it is mentioned at page 42.
Is there in the schedule?
Page 42, it has been mentioned that the present Kelly is under judicial custody.
And has
then-
moved for bail.
Sentence has been mentioned that he's likely to be released on bail.
No, and has moved for bail on 21.
You have moved for bail,
Yes,
and these are not offences. Therefore, I ask you whether you have been put under UPA. UPA is not there. NDPS is not there. So you may have got, you may get likely to get the bail. So they have, unless an effective. So they have given these are the grounds out there. Then record sponsoring. So this is there. Then grounds of now come up with any other ground.
there should be compelling reasons.
Huh?
There should be compelling reasons. So there is.
Compelling reasons, they say that you belong to the Senesian.
But compelling reasons that will be, he is likely to be released from bail.
Obviously, this is the compelling. If he's not detained, he's likely to indulge in similar prejudicial has moved bail, and if he's not detained, he's there. So you are in judicial custody at Central Jail and has moved bail on bail on 21/2026. So therefore, on 22/1/2026, they give it. You are arrested on that date. Now, the bail having not been granted subsequently, the bail, obviously, you are in preventive detention, obviously, you won't get it.
There is no movement.
So therefore, what happened to your bail?
When the bail was filed, thereafter, before the hearing of the bail, the detention order was passed.
So the bail order has become infructuous, bail application. Anyways, that is the problem. Now, what has happened? Any other ground?
Yes, because besides that, as per section 10, it is the materials, in the case of the activity has to be placed before the advisory board release. So, as per that, this case should have been placed before the advisory board on 12th of February.
12th of April. Because you were arrested on, you were detained on 22/1. 22/1, na?
Yes.
22/1/2026, and then yes, you are there, and it has to be placed within what time?
21 days.
Can you give us the NSA Act?
This is NSA, na? NSA.
In June, January, it was on 12th February 2026 corrections. And as per the filed by the internet government again. They have mentioned that the case of the it was referred to the advisory board on 6th of February.
Otherwise providing the penalties for the detention of the within 3 weeks from the initial person. So within 3 weeks.
Within 3 weeks.
So you were done on 22.
Yes.
1, 2, 3.
12.
1, 2, 3. So by 12th of February, they should have put you.
Yes, Your Lordship.
3 weeks. 12th of February. And when did they place it?
As per the report, in the affidavit filed by the government, it has been mentioned that the case were referred to the advisory board on 6th, 2026, but the advisory board set only on 1 February 2026.
That's a different aspect. The duty out here of the approver shall, within 3 weeks from the date of detention of a person under the order, place before so and so the grounds. Now, advisory board has been granted a time to deal with it. What is the time? The report shall specify separate opinion, and where there is a difference of opinion, nothing in the air. So they have to do it within a particular, within 7 weeks. After hearing him in person, submits his report to the appropriate government within 7 weeks from the date of the detention. Now, whether the order of detention within 1, 2, 3, 4, 5, 6, 7. Whether the authority have taken into account by 12th of March, advisory board.
I do not have.
12th of March, advisory board's report.
Yes, my lord, but this ground has not taken by the.
Forget about that. We We go in Article 21. Come on. You have confirmed it.
Yes, ma'am.
When you confirm it, you always put it out there,
Yes.
the advisory board's report. Where's the confirmation order?
14 April 2026.
Huh?
14 April,
Where is that?
page number 60A, capital A.
60.
Yes, sir. 60 capital A, and April 11A.
14th April. Here they will be mentioning, huh? Where is the detention of AR of so and so, returned by? Where is the AR? See, 9-3. 9-3. So they had to give within 9-3. So this has been done properly. That is why he has not taken point. Then you know case. Can't help you. Subjective satisfaction is there. No case.
Lordships, my humble submission is that although the case, the materials have been referred to the chairman of the advisory board, it has to be placed before the advisory board. So the advisory board constitutes the entire members, not only the chairman. So they sat only on 21st.
That's immaterial. Mr. Counsel, you see, from the date of the detention within 7 weeks, it is the duty of the advisory board to do it. The state have duly put it on 6-2. When the state have done it within 6-2, the advisory board having done on 12-3, and it was required to do it by 9-3, the period is done. No case. Can't help it.
Lordship, other ground which I'm thinking is that the offense charged can be tried by all the courts. So,
That is there, but therefore I ask you, these are not, you are not under UPA and all. You may get any day bail, these Arms Act and all these things. It is not bailable, but are there any stringent conditions? No, there. So therefore, they have a subjective satisfaction period within which it is being duly taken note of. Although this will be my first petition rejecting an habeas corpus, I think you will fall prey to that.
Lordship, in the grounds that we mentioned that.
Have you taken the ground that you have not understood, that I don't understand English?
No.
You should have. That is an important ground. You see, it has to be explained in the language in which detainee understands. Have you mentioned that? No.
No. But if I may be able to pray that.
That is a question of fact. You have to raise that, but other grounds you don't have.
Not to be mentioned the technical state economics, but
You see, the subjective satisfaction, the courts, normally it is not to be disturbed. Unless the subjective satisfaction cannot be the basis. If it is a case of UPA or NDPS, we could have very well said that he has never applied, in many cases he has not applied for bail also. Why on earth did you say so? But here he applied for bail on 21, and thereupon it was made infructuous, which is a different thing, and he was likely to grant bail. There is always an apprehension of the state also, taking into account that if he is very influential, you never know.
Lordship, basing on the gravity of the offense charge, he has been detained. So there is no guarantee that even if he has applied for bail, the bail will be done with his lordship.
That is, Mr. Counsel, that is the subjective satisfaction of the authority. We cannot replace that subjective satisfaction. You have to show that there cannot be a basis of the subjective satisfaction. First, you should have been very careful not to file that application. Or ask these people, put us under NDPS or UPA, where there are stringent conditions. then subjective satisfaction is not there.
He would not have been a chance that he will know that he will be taken under dissemination, so yes, like very important.
Okay, then we dismiss it.
Don't forget the government.
You have the records.
Yes.
The records not necessary. We have already seen it.
Thanks.
Not sure, one that who was arrested in the same fire.
Huh?
One that who was arrested in the same fire. This honorable court was pleased to release him, revolves the nation. Send parity maybe from project.
There's no bail parity out here.
Same grounds for project.
You do one thing. Next week I'm not there. So try your luck next week. Instead of getting a dismissal, next to next week. Not next week. Next week also you were not likely to get it. Next to next week. So next to next week we fix it. Then you may try your luck with that order. Parity. What do you say? Better? Then to get a dismissal. The moment I dismiss it, 1 year you will have to be there.
Let's see.
You are only there for 5 months now. So therefore, now and waiting for 2 weeks is better.
In that case, if I may be given the liberty to take it down that the detention order was passed in the language you not understand.
I think better off.
Yes.
We take that plea.
Yes.
Because that is, you see the judgment, in one of my judgments I have written it, though sitting in the single line was doing it, what's his name? I forgot. What is it? Herong Sang. I still remember the name. Herong Sang. That was my first judgment on these things. So there I have referred to one judgment of the division bench, of a division bench, and that referred to another judgment of the Supreme Court of 1964-65. You see the judgment of Herong Seng, where you build up your case in that manner. Herong Seng, it says that the person has to understand the language in which it was explained. Take a moment. Look into that.
I was thinking of placing one citation it was taught by law.
Which one?
In Srimati Amendment of American State.
Now here again, here you see these people were caught out there and registered under, you see this act. Husband of the year, so and so, parent year 142 of the Bharatiya, so and so, section 27(7) of the year. So this is under year he did not apply for bail also, I suppose. They have taken year of use.
Besides that, are we to rely on one citation, even if bail has been filed, then there should not be a ground for detention in purchase.
No, there's no question of ground of detention. No. You see, a bail having been filed cannot be a ground of detention. But a bail is likely to be given is a ground of detention. See, just for example, if there's a chance, they may go ahead. You see, you have to understand, if you see the judgment in Amina Begum and many other judgments, the Supreme Court categorically mentions that the court cannot step into the or look into the subjective satisfaction. You see, there is a difference between a subjective satisfaction and an objective satisfaction. Just now, if I am looking into the provisions as regards filing of, or as you mentioned, as regards the advisory board taking up after so and so and 21 days they did not say it and all this thing. That is objective satisfaction of section 9. Okay. But when a person has his own belief that yes, he is likely to be released on bail, that's a subjective satisfaction. 226 power is not there unless there is no materials to that. Anyways, I think you take up that Herongsan. Okay.
My lord, let them take sufficient time in matter after vacation.
No, this is a case of No. This is a case for habeas corpus. You have not filed a reply, na, Mr. Counsel?
Lordship, I filed additional
Petition.
No. Have you filed a reply? No. Okay, we give you that reply itself.
Yes, Lordship.
The counsel appearing on behalf of the petitioner submits that the state have filed an affidavit in opposition only on 29/5/2026 and submits that he has received the copy recently and he has to concur with his client as to whether the petitioner would like to file a reply. Considering the above, he therefore submits that at least 1 week may be granted. So taking into account the above, list this matter on 17th of June 2026. The reply be filed on or before 15th of June 2026. Look into Hera Singh.
Yes.
Okay.
Well,
What is item number 8?
May I plead the lordship? Actually, I'm appearing
In
for
your case.
8, my lord.
I read boundary. Get copy of form.
My lord, the detention order is at page number 22, my lord. Actually, my lord, here in this case, my lord, the very basis of PIT and DPS Act is violated, my lord. Some foundational facts are also shaky, my lord. Yes, my lord. Generally, PIT and DPS Act is applied for repeated offenders. But here in this case, my lord, what happened? That the relying case 1, my lord, that is PS case number 15 of 26, my lord, under section 21B, that is intermediate quantity, my lord. That only single case, my lord, relying case, that is 2, my lord. I was arrested based on confessional statement made by other accused. What was happened, my lord, in this case? Some contraband was recovered from a hotel of Dimapur, my lord. And thereafter, my lord, after inquiry, 2 persons were arrested from Assam only. Thereafter, my lord, based on their confessional statement, I was arrested. So I was purely arrested on confessional statement under section 67 of NDPS Act, my lord. Thereafter, what they did, my lord, during that my lord investigation stage, I applied for bail and accordingly bail was granted. But my lord, simultaneously, my lord, one separate proceedings were also initiated by the detention authority, my lord, under PIT and DPS. So, my lord, what happened? That some interesting facts, my lord, that detention authority was not even aware of the status of the detainee. Then, my lord, even they were not aware whether I am male or female. In that, my lord, PS case, my lord, the search sheet is not filed. Even the shocking part is that, my lord, the FSL report is not come, my lord, to ascertain the, my lord, this contraband, my lord, whether this falls under NDPS or not, my lord. So there are various, my lord, such type of, my lord, grounds are there, my lord. The relying case even is not, my lord, that where I was directly, they could not, you know, prove that where I was involved, my lord. My lord will come to page number, my lord, 23 of my petition, my lord, page number 23. Yes, my lord.
So there was no notice of given, ground of arrest not given to you.
Ground of arrest was given, my lord.
No, no, not here. When you were arrested in
Oh,
terms.
yes. Yes, my lord. In that earlier that PS case, my lord, what happened? That 48 notice was given. That is, my lord. That was wrongly, my lord. It was not me actually, my lord. So on that ground, that my lord trial court granted bail, my lord. The 48 notices annexed here, my lord. Page number I'm just yes 57, my lord. Page number 57 of the petition, my lord, will come. Ground of arrest, my lord, point number 1, dear lordship will find that if I read, my lord, that you being the relation of the accused Abdul Khan. So I'm not Abdul Khan, my lord. That 48 notice was, my lord, in violation of Article 21, my lord. Not properly served, my lord.
So that is why you got the bail.
Yes, my lord, we made submission. Thereafter, court was pleased to grant us bail, my lord.
When did you get the bail?
On 6th of, my lord, I was granted bail by 6/4/2026, my lord.
6/4/2026.
Right, my lord.
And when were you put under preventive detention?
On, my lord, detention order was of 9 April, but I was taken into custody, my lord, on 13/4. Detention order is 9/4/2026, but I was taken into detention on 13/4/26. So actually, my lord, this is total non-application of mine, my lord. Not only this point, my lord, other point is also dear, my lord, like they do not have knowledge, my lord, they were not aware that whether I am male or female. That is also, my lord, lordship will see in the page number, my lord, if you lordship come, page number 28, first lordship will come to page number 28.
Now, madam, you have a ground of detention that he is an active peddler. What is your basis? There is nothing mentioned in your affidavit in that regard. The affidavit which has been filed out here. Affidavit does not say on what basis you say that he's a trafficker and likely to be indulged. What is your basis? Any other, has he been an habitual offender? You have any case against him? Then I think we should release him. And interestingly, you kindly see grounds of detention. Number 3.
Page 23.
That you are presently under judicial custody. And on 6/4/2026, he was already released on bail.
As far as we're concerned, records which were with us show that he was still in custody. As far as the records that we have, and the lordship also should the fact that the bail was granted on 6th of April, and the detention was on 10th of April, so it was some few days. Yeah, and the lordship. And all
The 9th of April is the ground of the order of detention. But he was released on 6/4. So therefore, why did you put him on 13/4? You put this order when you arrested him. When did you arrest him? Show you. Huh? Where? Proposal for detention. Date of seizure, so and so. Date of time of arrest, 9/2. Yes, still exertion. 13th of April, meaning thereby he is not there. So if he was not there, you have therefore your very basis of your is wrong that you are under judicial custody. And there is no materials on which you can come to a finding that he was the person concerned. There was no materials that he is a habitual offender. That is one of your grounds which you have taken, that he is a habitual offender. Can you see your affidavit out here where it is said? That means, you see, kindly see, during the course of investigation, the detainee stated that he befriended Hassan and Usman during his school days in Imphal, and he agreed to deliver the heroin to Usman in Dimapur for financial gain. So and so had told this, that so and so, all documents relating to the case of the detainee was placed before AR, the special secretary. After careful examination of all the established facts and circumstances of the case, the detaining authority was satisfied. The detainee is a trafficker of so and likely to indulge. What is this basis? You have to show. That is why we call for the records.
This is, this description was found corroborative statements and CDR reports and bank transactions. That's the only record which were available to us.
So that is a question of investigation. Have you filed your charge sheet?
That record I have not.
I'm asking you, have you filed your charge sheet? Because you are required to file the charge sheet now. Because it's a case falling under 21B. What do you call?
Intermediate.
Intermediate.
Intermediate quantity.
It's an intermediate quantity. So therefore, he was only caught with 96, that too by somebody else was caught. May I allow this petition?
I have the request.
Okay, we'll have the reports. Heard,
M. Rahman.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so, who appears on behalf of the respondent numbers 127. 123 567. Mr. So-and-so appears for respondent number 4. Gustav. The petitioner herein, who is the cousin, na?
Mother of the detainee, my lord.
Huh?
Mother.
Petitioner is the mother of the detainee, my lord.
Is the mother of the detainee Amit Khan, has filed the instant petition challenging the detention order dated 9/4/2026. Made under the provisions of Section 3(2), under provisions of Section 3 of the PIT NDPS Act 1988.
My lord, pardon, my lord. I think it's 3-1.
Huh?
My lord, 3-1 is written in the order, my lord. Detention order.
Under Section 3(1) of the PIT NDPS Act 1988. As well as the other consequential steps so taken in pursuance to the said detention order. The records reveal that on 29/1/2026, while carrying out a surprise checking at around 20:34 hours, some suspected contraband drugs were found concealed inside a hoodie jacket inside room number 104 of Hotel Rhino, located near SBI main branch, Medical Colony, Dimapur, Nagaland. The customer oblique the occupant of room number 104 fled away from the scene. However, the ID card of one Johurul Islam was found. A seizure was conducted of the materials of the suspected contraband drugs, and a sumo motu FI was registered being East PS case number 015/26 under section 21 small b of the Narcotic Drugs and Psychotropic Substance Act 1985. In course of the investigation so carried out, a team of 6 members from the East PS left for Gauhati on 7/2/2026 on the strength of movement order issued by the Commissioner of Police Dimapur on 7/2/2026. On 8/2/2026, the team arrested the said Johurul Islam along with another person, namely Saiful Islam, and both were produced at the Bokhisto Police Station, Gauhati, Assam. It is the case of the detaining authority that, based upon the statement of Johurul Islam, the detainee in the instant proceedings, namely Amit Khan, was arrested on 9/2/2026 for involvement in PS case number 0015/26 registered under section 21B of the Act of 1985. When we have put earlier NDPS Act of 1985 bracket Act of 1985 for further investigation. It is very pertinent to mention that at the time of arrest of the detainee, while the ground of arrest which was provided to the detainee under section 47 BNSS mentioned the name of the detainee. However, in a notice which was issued under section 48 of the BNSS, it was mentioned that the name of the detainee was Abdul Khan. Based on that aspect, an application for bail was filed before the learned court of the
Special Judge NDPS Dimapur.
Special Judge NDPS Dimapur. And on account of the violation of section 48 of the BNSS, which constitutes a violation to Article 21 of the Constitution, the detainee was released on bail on 6/4/2026. Next. The records further revealed that when the detention order was passed on 9/4/2026, the respondent authorities, that the detainee authority was not aware that the detainee has been already granted bail. And this aspect would be apparent from the very ground number 3 of the grounds of detention, wherein it has been mentioned that the detainee was still in judicial custody. So, be that as it may, on the basis of the detention order dated 9/4/2026, the the detainee was apprehended on 13/4/2026 and thereupon continued to remain under preventive detention. It is under such circumstances the present petition was filed on 11/5/2026, alleging that there was no subjective alleging that the detention order was illegal, inasmuch as there was no subjective satisfaction which could have been arrived at before passing the said detention order. It is also mentioned in the instant petition that when there are various grounds taken in the grounds of detention, it could not be known as to which ground had influenced the detaining authority to detain. And under such circumstances, when the ground of detention was taken that the petitioner, that the detainee was in judicial custody, is on the face of it perverse, the question of the entire detention, the entire subjective satisfaction, which was the basic, which has to be the basis for the purpose of issuance of a detention order, did not survive. This court have also taken note of that pursuant to the filing of the instant petition, notice was issued and an affidavit has been filed by the detaining authority on 27th May 2026, wherein it is categorically mentioned that the detaining authority was provided with all the necessary documents which established that the detainee was a trafficker of NDPS and was likely to indulge in similar prejudicial activities unless prevented from doing so by an appropriate order of preventive detention. Next. This court have also taken note of, we have also perused the records which have been produced by Ms. So-and-so, the learned counsel who appears on behalf of the respondent numbers 1, 2, so-and-so, except now respondent number 4. Upon perusal of the said records, we do not find there being any other materials placed whereby which should show that the respondent, the detainee in question was a habitual trafficker, was a habitual offender under the provisions of the Act of 1985. Having perused the materials on record, as well as also taking into account the grounds, taking into account the affidavit so filed by the detaining authority, we are of the opinion that the detention which was made by the impugned detention order dated 9/4/2026 cannot be sustained in law. Inasmuch as the very basis of the subjective satisfaction, inasmuch as there was no materials on the basis of which a subjective satisfaction could have arrived at for carrying out the detention, for passing a detention order in terms with section 3(1) of the Act of 1988. So consequently, we set aside the detention order dated 9/4/2026. Next. We further direct the respondent authorities to release the petitioner forthwith if the petitioner is not required in any other case.
And what size of likely type of all this.
When you say, when you
That
say,
now becomes shorter. One year, I think you really do.
For orders, item number 9.
Your pleasure, Lordship.
What ground?
No, the ground is that, my first contention is that, the provisions filed by the state explaining the ground, explaining the subject, is specifically cannot be taken into consideration.
Why?
Because, my lord, the affidavit is, made by the special secretary home.
Hmm?
The affidavit, the respondent is the special secretary home. However, in the present case, the detaining of police is the commissioner of police, which is legislated in October. And we use the legislative, the beginning authority, who is to explain regarding the subject section. And not the present government. The government is telling the affidavit of the state regarding the significant government. That is the problem. Now, coming to my using my notes.
You were arrested when?
President in 33 2026
And detained on?
came on 8 April 2026.
You do one thing. You file an affidavit to the detaining authority.
No, but my other council.
Under terms, it's okay. You file an affidavit. Anyways, you are not going to get out from the bail. You are done under the UPA. You are there in UPA, Mr. Counsel. You are not likely to get it, but this thing, I think they need to file that affidavit. One opportunity we give granted, 1 week time we are giving, you file that affidavit through your detaining authority. Because there are many judgments also, which the subjective satisfaction should be explained by the detaining authority. You know what? So you do one thing, you file that affidavit next week. Next week. Next week. Anyways, because Mr. Sophia, we understand that you are there only on 33/2000. You were arrested on 33/2026. In view of you being arrested under this UPA, you are not likely to get bail in view of those provisions because it is only 2 months, says it. So let them file an affidavit. I understand your point. The other points I've understood, but the only thing is, in fact, they should not have detained it. I think that thing can be very well taken care of. Let them, because you see, we also understand. Yes, if it was at the end of the term, 6 months have gone, definitely we would not have granted. But as of now, I don't think even otherwise you would be granted bail. Let this be answered. Huh? Oh, that will pass it on next week. The other court will pass an order on 17th. Let them file an affidavit. Huh? See, the government could file the affidavit, the central government, and you have not been able to do. Mr. Langkumar, the counsel appearing on behalf of the respondent state, submits that the detaining authority would like to file an affidavit in this regard, and 1 week's time may be granted, taking into account that this court is of the opinion that this is a matter pertaining to seeking, challenging the illegal detention, and as such, this court is not willing to grant time to the detaining authority. We are of the opinion that the detaining authority requires to file the affidavit on or before 8th of June. 8th of June, Mr. Counsel. 9th of June. 9th of June. Full stop. List this matter again on 10th of June 2026. You file it, otherwise you are in trouble. There is another judgment of the Supreme Court, where it says it is the detaining authority who has to explain the subjective satisfaction.
For orders, item number 10.
How about I think what name element.
Who has filed the affidavit and when was he put out there?
Was arrested and filed for illegal also. Interpretation on excessive agents. First thing must cover.
Ground of detention. Yes, madam, here also you file your affidavit next week. The detaining authority is there, na? Same order. Just put on you.
What was I received at the state?
Huh?
I'm already received the affidavit from the state.
Understood, but this is being filed by the special secretary who is confirming authority, not by the detaining authority. Let them file, one chance is granted. Same order.
Commissioner of Police.
For orders, item number 11.
Same order, madam.
Yes, sir.
Same order here also. You filed that affidavit, maybe a same affidavit, but you have to
Yes.
file it through them. Explain it to your person.
For orders, item number 13.
It's for admissions or for orders?
As far as the A 23 is concerned, also this is to do with their site.
There's a challenge to what? There is a reference to the office memorandum. However, we do not find the office memorandum. Yes, you will.
No, this is the office number.
Regarding?
Regarding the regularized, no, workers and behavioral influence. This is the revised.
Then what is the order passed? We clarified that the dismissal shall not come in the way of the petitioner to pursue for regulation of a service career. Now, the petitioner's cases, they would be getting the right in terms with 50% of the area of Nagaland, so and so all departments are directly 50 of regular vacancies are relevant are to be utilized for absorption of workshops. So what is there, madam? Your case is duly covered. What is wrong?
After the list for the time before this, she immediately filed an application.
Ah.
And that application, because the authority of the right, it is a provision scheme. And as such, she's been, but, well, she was giving service, she was given only on a official business. And your lordship, during the previous period, your lordship is required, whether to commission it, and for this scheme existed at the time of and
My lordship, but this is that the police is very much in existence. That is.
You are a work church? You are a work church?
Lord,
So there was a speed ownership.
So they have modified the 16 line. Have they modified the 16 line order, office memorandum? Because that was also for 2004. That was for work charge
Lord, what you have taken. Put on.
and casual labors. Here also it seems that it is being the same thing. 50% of all regular vacancies in relevant posts are to be utilized for absorption of workers and casual in the regular government service for those employees who are duly verified and found genuine by the DLBC to the seniority. So and so will maintain a common seniority for 50%. So this is again same thing as per the seniority it would be and based upon vacancy.
Lord,
So this appears to be same like 16/9/2004.
Lord.
What is the difference here? This revised,
Lord, since I'm not aware with the earlier. Here, the case of the appellant here is that they approached this honorable court to consider on compassionate grounds. And that was dismissed.
Compassionate grounds, why?
They have approached this honorable court by way of filing a petition on compassionate ground. And that was dismissed.
There cannot be a regularization on compassionate grounds. Compassionate ground is a direct appointment.
Lordship.
That is foreign to 17/9/2015.
Lordship. So, Lordship, the time come to page 33, Lordship.
Page
Yeah, 33.
33.
33 of the film. Relevant would be paragraph 10.
I remember this case. The petitioner ought to have been granted appointment on compassionate basis at that. But she was appointed as a khalasi on a temporary basis. So therefore, when she was appointed as a khalasi on temporary basis, she continued like that. Now, therefore, she is asking that she should be, why was she not taken into consideration? And her appointment was in 2012 at that point of time. Madam, what was the office memorandum then? 2012? You have it? Now I get it. What it is? Which one? Oh, yeah. And when did you apply?
2009.
2009 applied for appointment on compassionate ground, was initially given appointment khalasi. Okay. But Mr. Jimomi, I think she has a case. In fact, I remember yesterday, 2-3 days back, there was a judgment of the Supreme Court, which now have changed the entire scenario in Assam as regards regularization. Here is a case that at that point of time, there was a compassionate appointment scheme. She was duly entitled to. There's no quarrel that her father or whoever it is was working in that particular office. Very well. She was entitled upon his death. She filed the application within that time. Now, after all these things, what you have done is you appoint her temporarily. She may have accepted it. But the fact remains, she has rendered her service. But she should have been regularized, not regularized, it's not a question of she should actually have been appointed on compassionate basis. And at that point of time, was there least business there? Appointment of irrespective
On
of
regular
the.
basis.
Huh?
So, effective.
It shall be made on regular basis. No, I'm not on that.
Mhm.
Now we have a list, na? Is there a list concept there?
But maintaining that list.
Oh, therefore, there is one list. Inter se person appointed under this shall be fixed with reference to their date of appointment and the interpolation with the direct recruit Pranati so and so and made. Shall be operative from first of year. All disputes so and so. So date of joining appointed under scheme shall be clear the date of her regular appointment. So then we can pass either two orders. Either we make it from the date she has become, she was entitled to be, then, or on the date on which she was appointed as a casual 18/8/2012, or you can, may give you that immediately you do it. Either three, which of the three? If we give it by 2012, then 14 years you have to pay arrears.
14 years, yes. From 2010.
Or do it prospectively from now. But give her, but if you do prospectively from now, but you have to give her seniority from 18th. But then you have a problem. In all other places, we don't have that problem. 1810, 18/8 with 2012, your whatever age you were, you cannot go beyond 30 years, na? So there shall be no arrears, but her seniority shall be considered from there. Then I don't think the government will have a problem. It is your mistake. You see, these people, where will these people go? You give them fallacies, they say, okay, let me get me 10 rupees also. We set aside this order, interfere and pass it on. But this, you are not financially hampered. She is entitled as per that scheme. There's no quarrel with that. She filed the application within time. There's no quarrel with that. Therefore, I'm not giving her arrears. If we don't put her seniority then you can't throw her out in 30 years. So as of now, she will have the seniority for 12 years, means another 18 years she can do. What is her age now? Huh?
37.
Repetitions, 36. So another how many years she will get? 18 years. She will retire in 54. But if we give it prospectively, from here she will do till 66. But she's entitled.
Because in 2012 itself, that scheme was there, isn't it?
Ah.
Compassionate appointment. And it's not disputed that the petitioner's father is the one who was serving.
No.
Therefore, she was entitled then itself.
From that day itself.
It's in violation of Article 14. What we say.
Also, by they are happily accepted. They accepted her.
They have no
Therefore,
choice.
we are not giving her the arrears. Although we are having only for the purpose of her pension and other benefits. So, we pass that order. I guess CAV, sir. Okay, CAV. We'll allow that petition, but they tired of giving dictation. Hey, come here, go to Asuni. It's not to teach someone.
For orders, item number 14.
Yes.
I give my query to. Getting for continuation of the for 76 days.
How much?
76 days.
Don't.
As a federal review for example, 1 and 2 months. But sometimes we will not for 5 minutes.
No, what is that? There has to be a finality. Hmm. 1 and 2. What about the others?
This is promoting.
Huh?
Like the private respondent. No one so no, against the provision given to the.
Who were the petitioners?
Petitioners for one and two.
And who is 3?
Three is private respondent.
She's also affected.
He is a beneficiary of that order promotion work. He is a promoting.
So,
Yes.
because of the order being passed
Yes.
by the learned single judge, 3 is also affected.
So if the appeal fails, then it will be trivial.
Understood? As of now, the appeal is yet to be admitted. So therefore, as of now, 3 is affected.
No, as a law in this.
Why?
She is also affected now. Because the normal single judge was, direction was to cancel the moment of the respondent number 3 and to consider the case of the respondent number 1 and 2. That was the direction of the.
Where is the judgment?
You are IA for one, mutual one is interesting. That's going to.
There was a vacancy in Spain, which is quite a issue. For that, respond number 3 is. So therefore, I'm saying, kindly see paragraph 12, page 226 of your judgment. Says that as such, the promotion of respond number 3 to the assistant manager by the impugn order dated is set aside. So if the appeal is admitted, it will be in favor of the respond number 3. That is what I'm asking you. What is your objection? No objection. Heard Mr. So-and-so, the legal counsel appearing on behalf of the applicant. Mr. So-and-so appears on behalf of the respondent number 1 and 2, who were the petitioner in WPC number. How many writ petitions you filed?
2.
Writ petitions number 263/264/2023. We have duly perused the grounds of delay as has been mentioned at paragraph number 6. And we are of the opinion that they constitute a sufficient cause for the purpose of condonation of the delay in filing the accompanying appeal. Accordingly, We condone the delay of 76 days in preparing the accompanying appeal against the judgment and order dated 19/11/2025 passed by the learned single judge in WPC number 264 and 2643 of 2023. Gusto, I stands disposed. Read appeal. List this matter for admission next week.
For the IA 40 or suspension of the common judgment.
Huh?
IA 42.
Ah.
That is for the suspension of the.
Absolutely no, Mr. Imsong. First and foremost, you file delayed and you want the suspension without admission. Not possible. List this matter, list the matter, you can read appeal number 10 as well as so and so. তাতে লিখি দিব the registry writ appeal number so and so লিখিব list this writ appeal for admission on 10th of June 2026 along with I number 42.
From the supplementary cost list for orders, item numbers 27 and 28.
The last official were directed to insert this on the full issue.
Application for
Information of delay of 1,709 days.
legal aid counsel.
Yes, sir. May I please vouch this?
Hmm.
Receive the service call.
Service of NORAD through PP allowed are for onward service. You have not been able to effect.
I've received the service call. So. So, but as per the court order, first, it has to be with the issue that existing. No, but also we got to from the entry, and when we filed the PPSL, it was the state council. Personal copy I have received. We practically released to the.
Who is to and fro?
You are Mr.
Issue of knowledge.
Mr. Counsel, tell me why you are putting the names? You have to put the names. Can you put the names of the complainant or the minor victim in your petition?
You cannot use the names of the victims. No. Even in the petition itself, you
It
cannot
has to
use
be
the names.
redacted, if I'm not wrong. But she's a minor. Find it out. Anyways, the copy has not been served, na? Because you are making, therefore, it is always done through the legal guardian. Why you are making number 3 a party?
Only 3, no. 2 should be deleted
My
actually.
lord, it was already in 9/04/2026. We were directed to text.
Understood, but this aspect was not looked into, na, Mr. Counsel.
Number 5 and 6.
She's 8 years as on the date of the judgment, on the time of incident. Incident of was on 21/9/2021. She'll be today for 13 years.
This one is not necessary. Victim is not necessary.
I know victim's name cannot be there. There's one judgment, but passed by the division bench of this Sandeep matter and me, I suppose. Wherein it is mentioned that you don't need to put the name of the year.
And plus the service on the complainant has to be taken through the office of PP. Route through the registry, but given to the PP so that they can serve through the jurisdictional police station.
We have done that motion. You said that.
So we do one thing, we strike off the name of respondent number 2. Okay. We may, she's a minor girl. We strike off her name and she'll be represented by, minor would be represented by the number 3. Number 3 is the guardian, no?
Yes. Number 3 is the complainant.
Huh?
Number 3 is the complainant.
That is what, who is the complainant? Father, mother, what?
No, village responsibility. Father.
Huh?
Father.
So she will be represented by her. This is an application file for condoning the delay of 1335 days in preferring the accompanying appeal. 1339 days in preparing the accompanying appeal. We have taken note of that in the instant application, the minor victim has been added as a party, as a respondent number 2. And the father of the minor victim has been arrayed as the respondent number 3. We are of the opinion that the name of the minor victim ought not to have been mentioned in the instant application. And accordingly, in as much as the minor victim would be represented by her father, who is the respondent number 3. Accordingly, we strike out the name of the respondent number 2, and the respondent number 3 is renumbered as respondent number 2. A fresh memo of parties be filed by the Mr. Counsel appearing on behalf of the applicant within 7 days. On the basis of that, the corrections would be carried out in the cause title of the memo of appeal as well as also in the instant interlocutory application. Further to that, we direct the counsel appearing, legal aid counsel appearing on behalf of the petitioner, appellants, to also, while serving copy of the interlocutory application to the for service of notice upon the respondent number 2, presently renumbered as 2, to strike out the name of the respondent number 2, the name of the minor victim. The said service be effected by serving a copy of the interlocutory application after making necessary correction as observed herein above, and served upon Mr. Ifom, the learned PP. Mr. Ifom, the learned PP, shall thereupon, upon receipt of the said application, copy of the application shall then effect service of upon the newly rearranged respondent number 2 through the officer in charge of PEC PS. Huh?
Police Station.
Which police station?
Chozuba Police Station, back to school.
So and so, Kisuma, so and so police station. Sozuba Police PS. List this matter again on he is there for a long period now. 17 is too early. Huh? 24th. On 24th of June. Huh? Do it through video conferencing? Because there is no other date. No? You see, it's a division bench matter. Single bench matter, division bench matter, I can't fix.
17th
17th is too early. Na?
after vacation.
After vacation is too long. Ask your junior to appear.
For orders, item number 29.
Like it's a lot of. For the instead I is for condemnation of the 5 days.
I for what?
Condemnation of the.
25 days.
Correct.
Who is the other side? Lima to, what is this matter about? Murder, POSCO.
I was also tried for POCSO, however, the same was not found there.
So we have to issue notice. Issue notice making it returnable on. Can you effect service upon the respond number 2?
Lordship.
Can you effect service on the respond number 2
No.
on 22nd of July 2026? Mr. K. Andami accepts notice on behalf of the respond number 1. Extra copy of the instant application be served upon him by tomorrow. As regards the respondent number 2, the petitioner shall take steps by speed post within 3 days. This is an this is an application for condonation of the delay of 25 days in filing the accompanying appeal against the impugned judgment and order dated 22/3/2026, passed by the learned court of the Special Judge Fast Track Special Court Dimapur, Nagaland in GR number 715/2020. Then issue notice.
For orders, item number 30.
This is the matter of the bill that is dismissed the rectification. There is a delay of 88 days in trying to and paying of termination of the delay and consideration of the appeal notice.
What is your ground?
But first of all, the expression of judicial discipline. And it's can consider page 5758 of which is the order of the 11th single judge.
So it was a mistake on the part of the council.
No, the respondent said both they have probated and approbated simultaneously. They
No,
took the
which-
appeal before the 11th single judge.
No, you
This is
see,
what-
Mr. Council, you say at paragraph number 2.
Yes, please.
The applicant submits that she is an indignant person, poor, jobless, who do not have any resources, residing in Woka town, and a counsel for the appellant, who are taking up the case pro bono, resides and practices in Delhi and Gauhati and have to travel from there, and that took time to discuss and initiate.
Actually, that's my associate who is based in working way from Nagaland. I'm in Delhi. She is absolutely poor because sometimes we are giving her money. And
What
we
is-
are giving it because the issue is.
What is the matter about? What is the matter about?
Matter is, look, she was working for the Nagaland government as a stewardess in the health department. Sports department, since 1984 to 2019, for almost 35 years. On a fixed pay of 300 rupees to begin with, 3,000 rupees at the last pay. And then one fine bonding without anything, they were just told that go back. You are gonna attain the age of 60, we can't keep you. So we are fighting that at least minimum wages act should have been complied with by the Nagaland government. She should have been confirmed in terms of Uma Devi judgment bills. That was applicable. So all rights have been violated, human rights, fundamental rights. They that civilize the state cannot treat a person like a modern labor rights.
Yes, madam, we condone the delay. We condone and fix it for admission next week. There is an application for condoning the delay of 88 days in filing the accompanying appeal against the judgment and order dated 31/2026, passed in WPC number 184/2023. We have perused the grounds on which the instant application, the grounds, we have produced the grounds stated as to why there was a delay in preferring the accompanying appeal. So we are of the opinion that the said grounds was so mentioned constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act 1963. We have also heard Ms. So-and-so, the learned counsel, appearing on behalf of the respondents number 1 to 4. Accordingly, we condone the delay of 88 days in preferring the accompanying appeal. And I stands allowed the raised. This is the list is I is there with appeal list this matter on 10th of June 2026.
Let's, well, no new operating on the necessary. So 10th amendment can consider very fixed.
Huh?
Case can be considered, but the panel hearing itself content.
It will come up for admission.
This to be admitted.
You try your luck.
Madam, when I said public me to join by DC.
There's no problem. Nowadays, we have a order being passed by the Chief Justice to do so. Everything over here, there's never a problem.
Because at that time, I mean, it's a much better to contact, I contact and then interact, physically with the court. I would prefer to feel.
I think
The partner matter is Supreme Court of Char in Gaziantep content. So if that is taken up, I will not be able to come. Otherwise, I will come.
that's you ask somebody else to do it. I'm fixing it. If you want on any other date, we fix it on 17th.
Degree sitting only on this day. The 17th, I'm before Chhattisgarh, I go 24th of cycle.
So therefore,
In Delhi. So
we have it on
only
10th.
15th of July, I can spare. So I will prefer 10 weeks.
We'll have it on 10th.
10 weeks.
For hearing item number 21.
Yes, what is this? Okay, we have it on some other day. Let's see what Mr. Jamil's matter is.
Next week.
Okay, is this matter next week? Yes, Mr. Jamil.
That's the matter we bring up next week for item 26.
You see, this matter would take some time because I was the person who issued notice.
Yeah, okay.
If I'm not wrong, the question is as to whether a person could have been brought within the fold of or promoted to this particular thing without clearing out some consideration or something. That was the basis on which you issued.
Yes.
I issued the notice, but I did not pass a stay order at that point of time. We said that it will be subject to. I think the matter got dismissed. Your repetition.
After the Lordship has issued the notice on 26, it was fixed on 30th. 30th month.
Yes.
When matter came up on 30th March.
It seemed to give me some water.
When
Yes.
matter was listed on 30th March, they came with the order by which that order was again superseded by another order, which was purportedly passed on 25th, one day before 26. So on 26, both my many friends they appeared, although it was in a admission state, they appeared, and they cannot appear without instructions. So they may have appeared on instruction of the client. Speaker was aware of the order. The secretary was aware of the order. But currently, they have not placed that order until this. And then only when the matter was fixed on 30th, they have furnished me that order by taking out from the so I had to withdraw and challenge the subsequent documents.
by
That's how the matter.
another writ petition.
Yes,
And that writ petition got dismissed.
yes,
And that is why we are here.
yes.
Okay. So we have it even next week.
Then we started this.
I am only telling you, Mr. Jamil, I'm just telling you. Next week also there will be, you see, we are taking up on if this matter would have come up last week, I would have very well had it tomorrow or any other day or having twice. The thing is, as of now, next week, the judge is only coming up for 1 week. So it may be difficult. But thereafter, the judge is coming for 2 weeks.
So will it be on the 17th or it would not be effectively dispose of the case? By this month itself.
You just tell us.
There is no harm in trying also.
Next week.
Let it be on 17th, because we would like to dispose of the case without putting it part time. For the interest of the parties.
Because you see, this matter. Wait the judgment.
Includes judgment is in page 28. And the fighting is at page 42, paragraph 26.
Vera?
Chiefs from 27, Madam Justice Nelson Silo is sitting. And there are 2 orders passed by Madam Justice Nelson Silo. So, in order to avoid that, in case if he finds it difficult.
No, but would it be a conflict of Justice Saylor to take up this matter?
No conflict.
Because I'm telling you I'm telling you, I'm telling you.
Express offer. Ask this order.
Why I'm telling you see, next week Justice Manish Chaudhary is coming. Then after that 2 weeks, Justice Nelson Silo is. Whether he will have a difficulty in taking up the matter.
No, absolutely not. In fact, Justice Gauhati also has passed an order on this case. So that way, if we go by that standard, then no one will be there. So, if it is 17th, we can dispose of that case.
Okay. Due to paucity of time, we adjourn the matters to be listed again on 17th of June 2026. Mr. C.T. Zamir, the learned senior counsel, appearing on behalf of the appellant, expresses urgency in the matter, and more particularly in view of the fact that there has been no interim directions passed staying or interim directions have been passed in the instant appeal. List this matter again on 17th of June 2026. Liberty given to the parties to mention the matter for upgrading. Has it been admitted?
Yes, also. 28 May order.
Just 1 minute, huh? 1 minute. I give you the liberty of the.
So hearing item number 23.
Mr. Counsel, we won't take it up today. Some other day, huh?
No.
It's already 4:30.
And it's the next week.
Huh?
Once, 24.
24th.
Not.
Due to paucity of time and the matter could not be taken up, list this matter again on 24th of June 2026.
For hearing item number 24.
Same,
Similar, similar or
Same one.
Your Lordship, I'm appealing for respondent number 1.
Yeah, 23, 24, same.